So while that's getting set up, I have for Ms. Rios, you can have 2 sets. You can give one to Ms. Wood, and I got a set for you, Ms. Dilligard. I revised the standing orders for case management and trial management. They're on the website. I'm giving you a hard copy as well, just to read so you know you guys will use them the most. That's one set for Ms. Dilligard. It's not any huge changes, but it is a refreshed version, and it makes sense to just review it and know what the basics are. That's 2 sets for Rios and Wood. Thank you. You bet. I don't think I need to see you on Thursday, though, because of your GBI person. You're welcome to come on Thursday, but there's nothing really to discuss. All right?
See you on Thursday.
Spared. Have a good afternoon. All right. Okay, final plea calendar. Only 15 minutes late. Today's final plea calendar, for those of you who can hear me and who are on it, if you do not resolve your case today, you will be on the March 13th trial calendar. So I will see you again on that day to sort out in what order we'll try your case. Today is the last day to enter a plea, should you want to do that, where you have the ability to withdraw your plea if the sentence that you get is different from what your lawyer asked for. You can withdraw it with no questions asked. There's not really a discussion. You say, Judge, I didn't get what I wanted. No thanks. And it's like it never happened. And then we see you on March 13th for the trial calendar. After today, you can still enter a plea. You just don't get to withdraw that plea if the sentence you get isn't what you asked for. Sort of like at a trial. If you're found guilty, there's nothing to withdraw. You get the sentence that you get. You'll just be in that posture rather than the posture you're in today. Having said that, let's dive into the calendar. Position 1 is Demetrius Jefferson. Is he supposed to be here? He's right there. Hey, Mr. Jefferson. Ms. Rios, what are we doing today with Mr. Jefferson?
A plea order.
All right.
Ready to go. I sent the plea terms.
Okay, I saw some of your email, your usual trickling in. So, Mr. Jefferson, we'll do your plea in a little bit. I'm just going to go through the calendar so we figure out who's doing what. Okay. Joel Lett, that is right here. Can you start your video, Mr. Lett?
Yes, sir.
There we go. Let me add you to the spotlight, and then I can't remember if your lawyer, I know your lawyer had a conflict. Was she going to dial in, or her conflict is such that she can't even be on the Zoom call?
She just had an earlier court hearing, so she should be here shortly.
Okay, then why don't we hold for her report? She let me know that she had this conflict, and I think she also said that maybe there was some late discovery, but I'll wait until she hops on the call. You may want to reach out to her to see when she'll be here, but please don't leave us until I circle back at a minimum to talk with you again, okay?
Of course, sir.
Thanks. All right. Robert Holliday is, I think I saw him on the call. Yes.
Hey, how you doing, sir?
I'm doing all right. How are you doing?
Doing good.
Good. Let me get your lawyer on as well. There we go. Ms. Wood, what are we doing with Mr. Holliday today? He's got 2 cases.
Yes, Judge. So we are not resolving these today. I'm asking that we keep the final plea rights reserved, simply because I got the offer yesterday and I just need more time to talk to Mr. Holliday, really, Judge. So, yes.
And from whom did you get the offer? Ms. Dilligard. Okay, I wasn't sure if it was, so they're both your cases?
Yes, Judge.
Okay. All right. So your request, Ms. Wood, is to preserve Mr. Holliday's final plea rights, and then we just move it to the trial calendar. If between now and then folks work things out, great. But even at the call of that calendar on the 13th, Mr. Holliday could still go forward with a plea, enjoying the final plea rights that he has today.
Yes, Judge.
Okay. Was the offer that you received something that strikes you as sort of being within the bounds of workability? Because if it's not, I don't have a problem with your request, but if you know if state offered 100 years to serve, we might as well just handle that final plea colloquy.
Well, Judge, it is a large amount of time the state is asking for, but I realized when Ms. Dilligard sent me the email that there's something about one of his cases that I don't think I've shared with her, so I'll need to have another conversation with her. So I think we can probably do the final plea hearing, Judge, as long as we just keep those rights intact.
No, we don't need to. I mean, if we're keeping the rights intact, there's no point in having the hearing. So we'll do what you requested. You have any objection to that, Ms. Dilligard?
No objection.
Okay. All right. So Mr. Holliday, we're not wasting your time. This is an important conversation to have, but we're basically going to maintain the status quo. I will see you at the latest in person, not virtually, on March 13th when we call the trial calendar for your two cases. I might see you before then if you and your lawyer have worked something out with the state. But on that date, March 13th, you'll still have your ability to withdraw your plea, should you decide to enter a plea, if I don't follow your lawyer's recommendation. Does that make sense?
Yes, sir.
Any questions about any of that?
No, sir.
How did you know that you had court today?
She called me, but I had already knew this court date was coming up.
Okay, and who's she? Your lawyer called you?
Yes, ma'am. I mean, yes, sir.
Okay, all right. Just want to make sure you're getting notice of the court dates, but I'm telling you right now, March 13th will be when I see you next. Ms. Wood, any discovery concerns? It sounds like you have some information you might share with Ms. Dilligard, but you feel like you're missing anything?
No, Your Honor.
All right, Ms. Dilligard, anything from the state on Mr. Holliday's cases?
Nothing further from the state.
All right, well, we will handle that way. Mr. Holliday, you're free to go.
All right, thank you. Have a nice day.
Mr. Lett, if you are still around, you are. If you'll pop your camera on, I see your lawyer, so we'll handle that conversation right now.
I'm going to court to March 13th.
Good afternoon, Your Honor. My apologies. I was running to the car from my other court, but good afternoon, Your Honor.
Afternoon. You don't need to apologize. You've been very diligent in reaching out to my staff saying, hey, I've got a conflict and we've got this situation and that. So we are going to talk about Mr. Lett's case in just 1 second.
Yes, Your Honor.
All right. Ms. Duvernay, tell me that I think your email said there was a concern about discovery. Tell me what your question or concern is, and then we'll work through what we're going to do.
Yes, Your Honor. Mr. Lett is a fairly young man, and this case may seem pretty simple, but there are some extenuating circumstances that he shared with me. In preparing for today's court, I was reviewing our case file, and I noticed that I received a certificate of discovery that was filed in October. However, we don't have any digital or hard copy discovery. I reached out to Ms. Nix via email once I realized that. Understandably, I didn't realize it late, Judge, but once I realized that, I reached out to Ms. Nix, and I got an email from Ms. Dilligard letting me know that she will be handling the case. And so, Your Honor, I was wondering if...
Uh-oh. She just disappeared. Ms. Dilligard, we'll let Ms. Duvernay get back on the call. Is it as simple as just sending another evidence.com link?
Yes, Judge, I'm requesting that it be done right now. I believe that the digital evidence was in a zip folder, so I don't know if that zip folder maybe is giving her issue.
Okay.
But I can research. I'm going to do that right now.
Okay. From your review of the discovery, is there any reason why the intervening month plus that we have before the trial calendar wouldn't be enough to wrap one's arms around it?
No, Judge, I believe that that's been plenty
Okay,
of time. That's my understanding.
all right. Well, Mr. Lett, I'm gonna have your lawyer log back on, and oh, she's back on.
I'm so sorry, Your Honor, and I do apologize. Would you like me to continue, Judge? I'm not sure of what you heard. My phone cut off.
No, you've helped me understand the situation, and after you cut off, Ms. Dilligard told me that she is having her paralegal resend the link. So you'll have something to click on that will get you to a zip file that if you then expand that, will have all of the digital evidence in the case.
Thank you, Judge. And so what I was going to request was, and thank you, Ms. Dilligard, for getting that to me so quickly. What I was going to ask, Your Honor, is if I could have time, a continuance to be able to review the discovery that the state is going to send. I did receive an offer last night. I can't gauge whether or not it's reasonable or not because I've not been able to review the discovery, but
Right.
I will be able to review everything. And by the next plea deadline, if the court were inclined to grant the request, we will be able to move forward with either the plea or announce ready for trial.
So I think I'm going to grant your request. What I'm going to do is what I just did for Mr. Holliday, which is to preserve Mr. Lett's final plea rights and let this move to the trial calendar. That's almost 2 months away. It's not being called until the middle of March, and then the week of trial is towards the end of March. Based on what Ms. Dilligard was telling me about the discovery, that ought to be ample time for you to review the discovery. Now, you may review it and say, wait a minute, I got a motion to suppress. That would slow things down, and that's fine. If you have a motion to suppress that needs to be argued and ruled on, we'll make time for that. But assuming there's not that type of material in what you're reviewing, it's more, all right, this is the strength and the weaknesses of the state's case. Obviously, you want to review that with Mr. Lett, then you'd be in a better position to engage with Ms. Dilligard on negotiations. But I'd like to keep the trial date that we've got right now, knowing that it may need to extend out if what I end up hearing from you is that you've got some substantive motions for us to work through. Otherwise, Mr. Lett was arrested back in 23 for this. It's time to try to get some closure. And so I'd like to keep the case moving along that path.
Yes, Judge. Well, thank you for that consideration. And you're right. With March, we do have plenty of time to review and go from there. So I thank the court for granting that.
Okay, so that's what we'll do. Mr. Lett, do you have any questions about anything we discussed?
No, Your Honor.
All right, so your lawyer will reach out to you after she's had a chance to review the discovery. I will see you again on March 13th at the latest. And it could be earlier if you and your lawyer have worked something out with the state or if there's a motion that needs to be argued, okay?
Sounds good.
All right, thank you both.
Thank you. May I be excused, Your Honor?
Yes, ma'am.
Thank you.
All right, Martise Tiller in custody. Is that your case, Ms. Nix?
Yes, Ms. Clark just asked me to come back and handle.
All right, are you and Ms. Rios talking about that case?
I didn't have an offer, I just need to see, he's been in Gwinnett, so it's been hard for me to actually.
So you want to chat with him?
Yes.
Okay, we'll see what happens. Possible plea. Thaddeus Lindsay, I think that's one you sent information on.
Yes.
Oh, Ms. Beza.
Yeah, that should be okay with me to go over his rights with him.
Okay. Quentin Rowland is here.
I need to talk to Mr. I haven't been able to talk to him.
All right, and Ms. Beza, also your case?
Yes, Your Honor.
And why have you not been able to talk to Mr. Rowland?
I think his number's off.
Okay. All right, well, you and he can talk about that. And then you'll let me know what's going to happen. Nicholas Burwell.
That will be a plea.
Okay, it's a busy afternoon. And Marcus Banks.
A plea.
He is here. All right, Ms. Dilligard, is that yours?
That is mine.
All right, this is the Rios show. Derek Rogers.
I do not have an offer for him yet.
Oh, okay. I have notes here that we'll talk about bond
Oh, yes.
at a minimum, but maybe we'll talk about other things. Is this your case, Ms. Dilligard?
This is my case, Judge. After reviewing this case, I spoke with the federal prosecutor that this may also be going federal, and so
Oh,
I was talking with her, and then I had to get circle around with Deputy Rowell about it. So that is kind of where that case stands at this point.
what part of this is federal?
It's a kidnapping across state lines. It's
Oh.
from Georgia to Alabama. So
Huh, okay, that is very federal. Okay, and is the initial response from the US Attorney's Office that they're interested? Here or in Alabama?
here.
Okay, thanks, Ms. Nix. I have position 11, Ms. Powell was diversion.
Judge. Okay, I think she might be on, and I just wanted to make sure there was an issue when she got accepted. There was some transition. I did get confirmation yesterday that she's got an orientation date, but she did just want to log on to make.
She is on. Ms. Powell, can you turn your camera on?
Yes.
Hey, Ms. Powell, give me 1 second, get you on the screen here. There you are. And we'll get Ms. Wood on as well. So Ms. Wood, you're saying that Ms. Powell has been accepted into, this is the district attorney's diversion program?
Yes, Judge.
Okay, you just want to make sure Ms. Powell knows that so that she attends orientation.
Yes, because when she got notice for this calendar, we still hadn't heard back confirmation about when orientation was. I got that notice after I spoke to her yesterday and I forwarded to her, and I just wanted to make sure that she received the email.
Okay. Ms. Powell, Ms. Powell, do you have any questions about the diversion program or when orientation is?
No, not at the moment.
Okay, well, as long as you comply with all the requirements of the diversion program, then when that's successfully completed, your charges get dismissed. If at any point you run into any confusion or friction with that, you should reach out to Ms. Wood so that she can help you navigate that, okay?
Okay.
Now, I'm sorry, Judge. This is her sister. I do have one question. She told me as part of the program, she has to be in school or working. Is that correct?
Lawyer is saying yes.
Okay, because we've been having trouble because of the charge with getting her a job. Like I have desperately tried in the field that I'm in, and it's hard with the background situation to get her a job.
Okay, fair point. I suspect, but it may be that one of the prosecutors here could confirm this, that if your sister, if Ms. Powell is demonstrating a good faith effort to get a job, like here are 5 applications, but she's not able to secure one, that's satisfying that requirement. Because you raise a good point. If people are reluctant to hire your sister because of the pending charges, that's not your sister's fault is the wrong word, because of course she has the pending charges, but it's an explanation for her not having a job.
Exactly. Okay, thank you. I appreciate it.
Sure. Ms. Dilligard, anything else on Ms. Powell's case?
No, Judge.
Okay. Ms. Powell, do you have any other questions?
No, I do not.
Okay. Ms. Wood, anything else on behalf of Ms. Powell?
No, Your Honor, thank you.
All right, Ms. Powell, thanks for joining us. You're free to go.
All right, and thank you.
You bet. And then we've got Ethan Brown.
I think he's on the call, Judge.
Ethan's on the call. Okay. Oh, there he is.
Hello, hello.
Hello, hello. There he is. All right. Ms. Wood, let me add you. There we go. What are we doing with Mr. Brown's case?
Same posture as Mr. Holliday's, Judge. I'm actually waiting on an offer on this one, and so if we could just preserve those final plea rights and push it to the March calendar, that would be my request.
Okay. Any discovery issues?
No, Judge.
Okay. Ms. Dilligard, any objection to preserving Mr. Brown's final plea rights and just slide this to that March trial calendar?
No objection, Judge. For this case, It's likely gonna resolve to a misdemeanor. I'm just trying to get in contact with the victim and have not been able to just yet, and so that's why I haven't sent over a formal offer just yet. I really want to communicate with her first. We've tried her mom and we've tried to locate her, and so we haven't been successful just yet. And so we have no objection to moving it to the March calendar.
Okay, sounds like a plan. Mr. Brown, we're preserving your final plea rights. It sounds like the offer is going to be a misdemeanor in the end. No guarantee. Don't take that to the bank. And that may not be something you're interested in anyway. But I will see you in March for the trial calendar. That doesn't mean you're going to have a trial. That's just when we will likely talk again about the case. But if you and your lawyer sort it out before then we'll get you in here or virtually. If it's a misdemeanor, it's the kind of thing we could probably do over Zoom like this. And we'll sort your case out then. Do you have any questions about any of the things we've discussed?
No, sir.
Okay. Ms. Wood, anything else on behalf of Mr. Brown?
No, Your Honor, thank you.
All right, Mr. Brown, how did you know you had court today?
Through my mail and my lawyer.
Good. All right. So if you move for some reason, make sure you tell your lawyer. Otherwise, we'll get something in the mail to you for your next court date.
All right. Yes, sir. Yes.
All right. You're free to go.
Judge, may I be excused as well?
I think so. I want to see who else is on the call. Some people have been dropping. I just want to make sure you didn't have any clients on the call. But we know how to find you if they're here for you. So we'll turn to the Rios show now. All right. Was there anyone here who had a case and they didn't hear it called? Ms. Rios, is there anyone you'd like to talk to first?
I would suggest I have 2 pleas ready to go, and then I have three pleas that I just need to talk to them a little bit. So we can do the 2 pleas and then give a break and then do the rest.
Sounds good.
And the ones that are, I have Demetrius Jefferson and then Marcus Bates.
All right. Is Mr. Bates here? Okay. No, I wasn't saying he goes. They're both out here, so we can go in whatever order you want. I was just going to check with the deputies if they had a preference if someone was in custody, but they're both not in custody. So you pick.
Let's do Jefferson first.
All right, Mr. Jefferson, come on up to the podium up here, please. And Ms. Dilligard, if you don't mind, I'm gonna have the plea taker or giver be in the witness box area. You ready?
Ready.
Okay, let's go on the record in State versus Jefferson, 24 SC 003616. Mr. Jefferson, you are ready to enter a plea in your case?
Yes.
Ms. Dilligard will put you under oath in just a moment, ask you a bunch of questions. If at any point you've got a question, please let Ms. Rios or me know that, okay?
Okay.
All right.
Mr. Jefferson, please raise your right hand. Do you swear or affirm that any statement or testimony that you should give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, you can lower your hand. Please state your true, correct, and legal name for the record.
My name is Demetrius Boyd Jefferson Jr.
Okay, and are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No.
Is there any medication that you normally take that you have not taken or been given today?
No.
How old are you?
I'm 24.
And how far have you gone in school?
I graduated 12th grade.
Okay.
Where'd you go to high school?
Arabia Mountain High School.
Do you understand that you have been charged with the following offense? 1 count of felony fleeing or attempting to elude a police officer? Do you understand that you have the right to plead either guilty or not guilty to that charge? Do you understand?
I need verbal responses.
Yeah, I'm sorry, you got it out loud rather than, you're welcome to nod your head or shake your head, but I need a yes or a no or maybe or whatever your answer is. All right. So let's do that question again.
Okay. Do you understand that you have the right to plead either guilty or not guilty to that charge?
Yes, ma'am.
You understand if you plead not guilty or remain silent and refuse to enter any plea at all, then the state is required to prove the charges against you at a jury trial?
Yes, ma'am.
Have you had an opportunity to review the waiver of rights form with your attorney?
Yes, ma'am.
Have you had enough time to speak with your lawyer about the charge in this indictment against you?
Yes, ma'am.
Would you like any more time to discuss the case with your lawyer?
No, ma'am.
Are you satisfied with your lawyer's services?
Yes, ma'am.
Counsel, did you waive formal reading of the indictment for purposes of the plea?
Yes.
And did you waive any and all defects in the indictment for purposes?
Yes.
The state is unaware of any outstanding warrants related to these charges. Mr. Jefferson, do you remember being arrested for this charge?
Yes.
Has your attorney advised you of the minimum and maximum sentence for this charge, which you're pleading today? So you're charged with felony fleeing but you're pleading to a reduced charge of reckless driving pursuant to 46-390. For felony fleeing as charged, the minimum is 12 months, the maximum is 10 years. Do you understand that?
Yes.
Okay, and for reckless driving, the maximum is 12 months in jail. Do you understand that?
Yes.
Do you understand that today you're entering a negotiated plea of guilty, which means that the state will recommend the following sentence to the court? Judge, we're recommending that the felony fleeing be reduced, like I said, to the reckless driving pursuant to OCGA 40-6390. The sentence would be 12 months probation, 40 hours of community service, and no driving without a valid license, registration, or insurance. Is that your understanding of the recommendation?
Yes, ma'am.
Do you understand that the court is not required to accept the state's recommended sentence?
Yes, ma'am.
Do you understand that the court has the right to sentence you to the maximum possible sentence on this charge?
Yes, ma'am.
Do you understand that if the court decides to order a sentence that differs from the plea you were expecting today, that you'd have the right to withdraw your plea?
Yes, ma'am.
Do you understand that if you're currently on probation or parole, that your probation or parole may be revoked based on your entering of a guilty plea?
Yes, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
Yes, ma'am.
Do you understand that if you're on probation, you must follow all of the special conditions of your probation?
Yes, ma'am.
Do you understand that if you fail to follow all the special conditions of your probation, then you'll be subject to revocation of that probation for the balance of your sentence?
Yes, ma'am.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Are you a United States citizen?
Yes.
Are you asking to be treated under first offender? Ms. Rios?
No, it's a misdemeanor.
Okay. Do you understand that by entering a plea of guilty today, you're waiving any and all defenses, including any mental health defenses?
Yes, ma'am.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to the assistance of counsel, the right to the presumption of innocence, the right to appeal if convicted of these charges at a trial?
Yes, ma'am.
Is it your decision to waive these rights, which means not to use them, and enter a guilty plea today?
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is your decision to enter a guilty plea because you are in fact guilty?
Yes, ma'am.
Mr. Jefferson, how do you plead to the charge, the reduced charge of reckless driving in indictment number 24 SC 003616?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charge against you?
Yes, ma'am.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes, ma'am.
You understand that for a misdemeanor charge, you only have 12 months from today to file a habeas corpus petition?
Yes, ma'am.
Judge, if this case was to proceed to trial, the state would be able to prove beyond a reasonable doubt that officers pulled over the defendant, Mr. Demetrius Boyd Jefferson, for having an expired registration. They were able to pull up next to his car where his backseat windows were down. They were able to get a good up view of his face and match that photo to his registration that they ran previous to. The defendant then fled at a high speed. And he did not maintain his lane, swerving in and out of traffic. Officers were not able to apprehend him that day, but warrants were taken out and he was arrested later. And this all occurred in Fulton County, Georgia. In full candor, there was no body cam or dash cam that was turned on during this incident. And so that is part of the reason for the reduced charge.
Okay, thank you. Good afternoon, Ms. Jackson. How are you?
Good. I'm doing well, and yourself?
I'm all right. Can you share whatever criminal history information you have on Mr. Jefferson?
He has 2 cycles. The last arrest was December the 21st, 2020, out of Clayton County for a misdemeanor theft by shoplifting. He has 1 misdemeanor conviction that was in 2022 out of Clayton County for misdemeanor theft by shoplifting. Nothing in addition, Your Honor.
Thank you so much. Ms. Rios.
Yes, Your Honor. Mr. Demetrius Jefferson Boyd is 24 years old. He has been doing his own photography business for a while. He also starred in a TV show called Florida Boys.
Florida Boys?
Yes.
Okay.
And he's planning on doing other projects. That's the field that he would like to be in. He did graduate high school and he doesn't have any children and no history. So I'm asking you to accept the plea as negotiated.
Got it. Mr. Jefferson, what is Florida Boys?
It's this reality TV show that I was on.
Okay, but like, what was it? Are you from Florida?
No, I'm not from Florida.
Okay, so it wasn't so realistic?
Right.
Okay, and what role did you play on Florida Boys?
I was an actor.
As in you played the role of an actor?
Yeah.
Oh, okay.
Like a reality TV star.
Were there Florida girls on the show?
Yeah.
Okay. Was it enjoyable?
Yes, it was.
How many episodes, if that's what they call them, were there?
It's about 10 episodes.
Okay. And would someone find this like on major television, or this is like ESPN 12?
It's on Unexpected TV.
Unexpected TV.
It's on app. It's on an app. You can download it on Roku.
Okay. Would it be safe for kids to watch, or this was like adult reality?
Adult reality.
Adult reality. How did you land the gig?
I knew the owner.
Okay. But these days it's more photography that you're doing?
Yes.
All right. Do you have any questions about anything anyone said? No?
No.
Okay. Anything you want to add? No?
No, sir.
Okay. Why the haste to get away from the Georgia State officer?
I have a different mindset now, but I was younger then.
This was a long time ago. This was December 21.
Yeah.
Okay. But it was, I mean, was it, I'm scared, or I can beat this guy?
I'm scared.
Okay. Did you have, I guess you didn't have a valid registration at the time?
Mm-mm.
No? Okay. All right. Well, Mr. Jefferson, I find there's a factual basis for your plea. I will accept it. I also find that your plea is knowing and voluntary, meaning you've understood what we talked about. No one's forced you to enter the plea. See if there's anything else. Don't need to do any of those things. Given that how much time has passed and how clean, relatively speaking, your record is, I'm going to sentence you to 6 months probation. You will need to do 40 hours of community service. And I'm not going to add the requirement that you not drive without a valid license, because if you do that, that's a ticket anyway. And the surest way to turn your probation into a little bit of jail time would be to be back here in front of me and you didn't have insurance. Do you have a valid license now?
Yes.
Do you have it with you?
Yes.
Okay. Is it a Georgia license or a Florida license?
It's a Georgia license.
With your name on it?
Yes, sir.
Excellent. Keep that. Keep good insurance. Do you have a car?
No, not right now.
Okay. How do you get around?
Marta.
MARTA. Okay. Do you have a MARTA card? No. Okay, don't fair jump either. But that's what we're gonna do. So it's the community service, 6 months probation. Ms. Rios will let you know how to connect with misdemeanor probation. It's not felony probation. So it may just the whole time be something where you do it over the phone. There's a slight supervision fee, but you'll pay that each of the months that you are on probation. Ms. Rios, can someone in my office sign the indictment indicating your client's misdemeanor plea?
Yes, Judge.
Ms. Dilligard?
Yes, Judge.
And Mr. Jefferson, can we sign it for you?
Yes.
Okay. Ms. Rios, anything else on behalf of your client?
No, Your Honor. Thank you.
Ms. Dilligard?
Nothing further from the state.
All right, good luck. I expect to see you on something that's not just on unexpected TV.
Thank you.
All right. Give me 1 second. This is Mr. Banks? Great. All right, 24 SC 004287, State versus Marcus Banks. Mr. Banks is here in court with his lawyer, Ms. Rios. Ms. Dilligard is here for the state. Mr. Banks, you just watched the plea. We're going to do the same thing. You're going to get put under oath, asked many of the same questions. You need to make sure you answer out loud, in other words, verbally, so the court reporter who is on one of these screens can take all that down. And if at any point you're confused by what's going on, or you've got a question, will you let Ms. Rios or me know?
Yes, sir.
Great. Ms. Dilligard.
Mr. Banks, please raise your right hand. Do you swear or affirm that any statement or testimony that you should give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Please state, you can lower your hand. Please state your true, correct, and legal name.
My name is Marcus Cornelius Banks III.
Mr. Banks, are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No, ma'am, I am not.
Is there any medication that you normally take that you did not take today?
No, ma'am.
How old are you?
I'm 26 years old.
And how far have you gone in school?
I made it to 12th grade.
Do you understand that you have been charged with the following offense? 1 count of robbery by sudden snatching.
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to this charge?
Yes, ma'am.
Do you understand that if you plead not guilty or remain silent and refuse to enter any plea at all, then the state is required to prove the charge against you at a jury trial?
Yes, ma'am, I do.
Have you had the opportunity to review the waiver of rights form with your attorney?
Yes, ma'am.
Have you had enough time to speak with your lawyer about all the charges in this this charge in this indictment, including the facts and circumstances relating to that charge?
Yes, ma'am, I have.
Would you like any more time to discuss this case with your lawyer?
No, ma'am, I don't.
Are you satisfied with your lawyer's services?
Yes, ma'am.
Counsel, do you waive formal reading of the indictment for purposes of plea? Do you waive any and all defects in the indictment?
Yes.
Do you remember being arrested for this charge?
Yes, ma'am, I do.
Has your attorney advised you at the minimum and maximum sentence for the charge which you're pleading guilty to for robbery by sudden snatching, the minimum being 1 year, the maximum being 20 years?
Yes, ma'am.
Do you understand that today you are entering a negotiated plea of guilty, which means that the state will recommend the following sentence to the court? Judge, the recommendation is 5 years probation to the charge indicted, 60 hours of community service, to take an anti-theft course, to stay away from all Walmarts in Fulton County. He's to write an apology letter to the victim within 30 days of taking the plea. No contact with the victim outside of that letter. And there's restitution in the amount of $12,340 to Walmart.
$12,340?
Yes, Judge.
Okay.
Was that your understanding of the negotiation?
Yes, ma'am.
Do you understand that the court is not required to accept the state's recommended sentence?
Yes, I do.
Do you understand that the court has the right to sentence you to the maximum possible sentence on this charge?
Yes, ma'am.
Do you understand that if the court decides to order a sentence that differs from the negotiated plea that you are expecting today, that you have the right to withdraw your plea of guilty?
Yes, ma'am.
Do you understand that if you're currently on probation or parole, that your probation and parole may be revoked based on your entering of a guilty plea today?
Yes, ma'am, I do.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
Yes, ma'am.
Do you understand that if you're on probation, you must follow all of the special conditions of your probation?
Yes, ma'am.
You understand that if you fail to follow any of the special conditions of your probation, then you will be subject to revocation of that probation for the balance of your sentence?
Yes, ma'am, I do.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am, I am.
Are you asking to be treated as a first offender under the provisions of the First Offender Act?
Yes, ma'am.
Have you pled guilty to a felony in the state of Georgia?
Like 17. Not sure. I don't have any felony convictions. I don't.
Then the answer would be no.
Oh, no.
Okay. Have you ever been sentenced for any crime, or have you pled guilty to a felony in any other jurisdiction?
No, ma'am.
Have you ever been sentenced for any crime, whether felony or misdemeanor, under the First Offender Act?
No, ma'am.
Has your lawyer explained the First Offender Act to you?
Yes, ma'am, she has.
Do you understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status can be revoked?
Yes, ma'am.
Do you understand that by entering a plea of guilty today, you're waiving any and all defenses, including any mental health defenses?
Yes, ma'am.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to the assistance of counsel, the right to the presumption of innocence, the right to appeal if convicted of these charges at trial?
Yes, ma'am, I understand these rights.
And is it your decision to waive these rights, which means not use them, and enter a guilty plea today?
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter this guilty plea?
No, ma'am, they have not.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes, ma'am.
Mr. Banks, how do you plead to the charge of robbery by sudden snatching in indictment number 24 SC 004287?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition?
Yes, ma'am.
Do you understand that for a felony charge, you only have 4 years from today to file that petition?
Yes, ma'am, I do.
At this time, Judge, give you a factual basis for the plea. If the state was to move forward to trial, we'd be able to prove beyond a reasonable doubt that on January 12th of 2022, this defendant entered a Walmart store. Based on the interview with the victim, the accused was standing around the front corner area. When he saw the victim, she had a cash drawer in her hand. She had just gotten to work. There was a brief struggle. He was able to snatch the cash drawer from her person and take the money. The drawer dropped. Officers were able to lift a fingerprint from that drawer, which is how it connected to the defendant before us today. The state has had constant contact with the victim in this matter. Unfortunately, she was not able to attend today. However, she did write something that she wanted me to speak on the record. Is that okay?
That's always okay. And this is Ms. Hines,
Yes.
and she was, maybe still is, a Walmart employee who was basically setting up a cash register and had that cash tray or money tray taken from her by Mr. Banks.
Yes, Judge.
Okay.
She writes, I've waited 2 years to get justice for what was done to me. I came to work with the intention to take care of customers and to do my job duties, only to be robbed and taken the store money from me. I want you to know that you not only robbed the store, but you indeed robbed me from my sense of security. I worked at Walmart for 14 years at the time of the robbery. She loved what she did, and it was a career for me only. I love what I did, and it was a career for me only for you to take that away from me. After the robbing, I went on leave of absence and was hospitalized for 7 days at a Ridgeview hospital where she received some medical treatment for PTSD. Her leave of absence lasted 2 years. I feared entering the building and the monster coming back. I have nightmares of the day, my peace you took, and my ability to take care of myself and my son financially. Words couldn't describe how much pain, fear, and loss you brought to my life. I only forgive you because God has allowed me to not give up. And I know in my heart that's the best thing to do. Although I couldn't be there, I pray that you hear and feel the words of what's been stated on my behalf. I ask the judge to give justice to this case. No matter what the sentence is, I will never have my sense of security back. I have to be reminded of that day every morning when I take my anxiety pills. I do pray that you have changed and that you understand that I didn't deserve what you did and that you are for the better moving forward.
So Ms. Hines clearly is in touch with you because you got that from her. Does she understand what the state is recommending in this case?
She does, Judge. I think she was looking for a little bit of jail time. I explained the case with her, the defendant's criminal history, and let her know that this is what the state feels is the best recommendation for the case.
Okay. And what I took from her statement was that, number one, this was extremely traumatic for her, but two, the 7 days in the hospital had much more to do with emotional well-being and not that Mr. Banks hit her on the head with an axe or anything like that. It was, I don't mean to minimize what she went through, but it was not physical injuries because she was beaten or assaulted by Mr. Banks. It was the trauma of going through what she did.
That's correct, Judge.
Okay. All right. Thank you. Ms. Jackson, criminal history information on Mr. Banks, please.
He has 3 cycles. The last arrest was December the 13th, 2016 with the City of Atlanta Police Department for driving without a valid license. He has 1 misdemeanor conviction. It was in 2017 for driving without a valid license. Nothing in addition, Your Honor.
Thank you. Ms. Rios, this doesn't line up with anything else Mr. Banks has done on the record. So I'll hear from him as well, but talk to me about your client and this situation.
Yes, Your Honor. Right now, he is in the process of getting his GED. He went up to 12th grade. He was working for the airport. He hasn't been able to get his job back from the airport because he can't, he said there's some issues with being on bond and working at the airport, but he is pretty sure that he's able to get his job back once this case is resolved. He has 1 child who's 3 years old. He's 26 years old, Your Honor. At the time, he was about, I guess, 22 or 23. He's ready to put this behind him and do better and make sure he's able to work, provide for his child.
All right. Mr. Banks, what kind of work did you do at the airport?
I was security for Worldwide Flight Services.
What does that mean you did?
I was in charge of badging people coming in and out of the building, making sure that people who weren't in the building or not in the building, going through making security checks, making sure nothing is breached and things of those nature.
Okay. And have you talked to anyone there about whether they would take you back after this case is resolved?
Yeah, the main problem was me not being able to get a badge. You have to have a badge in order to be on airport premises. So that just was the biggest problem.
Why could you not get a badge?
Because I'm on bond and stuff. I guess I wasn't cleared.
Okay.
I was cleared through the fingerprints, but you have to do something totally different, and they didn't clear me for that part.
All right. Ms. Rios, is this a first offender plea?
Yes, Your Honor. I'm asking for him to be treated as a first offender and a behavioral incentive date of 3 years once restitution is paid.
Okay. Ms. Dilligard, I'm guessing because there's restitution, whatever was in the drawer that Mr. Banks got, he got away with. It wasn't, he stopped at the scene. It's the fingerprint on the drawer that connected him to the crime.
Yes, Judge.
Okay. Boy or girl, your 3-year-old?
She's a girl.
Okay. Does she stay with you or her mom or someone else?
She's with her mom.
Okay. How often do you see her?
I'm actually going through another court trying to get custody and stuff like that.
Okay, full custody or just shared custody?
Shared, since I don't have any rights.
Okay. Has Ms. Rios talked to you about first offender?
We've chatted a little bit.
Okay. First offender is an opportunity primarily that you qualify for because you don't have any felony convictions. It means if I sentence you as a first offender that when you leave here today, you don't have a conviction. You will be under sentence, you'll be on probation, but it's as a first offender. So if you're going through a background check or applying for a job, you don't need to check the box that says convicted felon because you're not. And that's how it will stay if you get through probation successfully. The risk, the downside of first offender is that if we're back together again in a year because you did something like this, or basically you get arrested for anything serious, not only do you have the new charges, but I could revoke your first offender status and resentence you without a trial. You'd have a hearing, but no trial because you've already pled guilty. And I've got up to 20 years to work with on this charge. So I'm not saying you get 20 years, but if we're back here in a year and you grab the phone out of someone's hand because you were feeling desperate and you sold that phone, but you did another robbery by sudden snatch or worse, you had a weapon on you, I would revoke a bunch of that first offender, but it wouldn't even be a revocation. I take away your first offender and then resentence you and say, I misunderstood who Mr. Banks was. And now it's going to be 15 to do 10 or something like that. And that would flow naturally from it. That's the risk of first offender. If you're going to succumb to whatever was in your mind in January of 2022 and do that again, then first offender is a bad idea. Do you feel like you understand the benefit of first offender as well as the risk?
Yes, I do.
Is that something you want to try?
Yes, sir.
Okay. Why do you think it'll work out for you?
I'm not a problem person. I don't get in any trouble. I tend to mind my business, go to work, go home, take care of my family, go home.
But what about this?
Once I get rid of this, it's going to be behind me. I want to do whatever I can in my power to fix whatever is going on, change, and I just want to fix it and move on from it.
Okay. I didn't ask my question well. You just told me that you aren't someone who gets into trouble. You do your work, you go home and take care of your family. But in January of 2022, you stole $12,000. That's a lot of money. Did you know how much was in the drawer? What caused you to do this?
I had just had a little girl and I ended up losing that particular job I had because something was going on with the maternity leave. They said that I didn't put my 2 weeks notice in. So I ended up losing my job. And around that time, the mother of my child just gave me problems if I didn't have anything to bring to the table, or I did the best that I could and I made a stupid mistake and I can't do anything to change it, but move on and be better from here today.
Okay. Well, that's the right approach to try to move on. Did you know how much money would be? It surprises me how much money is in a Walmart cash drawer, but I guess they do a lot of business.
No, I actually didn't. It just was a random thought, like impulsive, just going through things and stuff like that. That my emotions get the best of me instead of thinking mentally.
Okay. You didn't know this lady who was handling the drawer. Was she a stranger to you or someone you knew?
I didn't know her.
Okay. All right. And what'd you do with the money?
Trying to be a better father for my child.
You spent it?
Yeah.
Okay. That's a lot of restitution. You don't have to pay it back all at once, but that's going to be something that you are paying down every month as you're getting your paycheck. Some of that's going to go to probation so they can get it back to Walmart. You understand that?
I have no problem with that.
Okay. All right. Anything else you want to say?
I just want to be a better person. That's it. I'm just trying to move past this and continue trying to be the best person that I can be for my daughter and my family.
Okay. Well, Mr. Banks, I find there's a factual basis for your plea. It sounds like you were going through a lot at the time. That doesn't justify what you did, but it explains what was going on in your head. I also find that your plea is knowing and voluntary, so I'll accept it. I'm sentencing you pursuant to the Probation Options Management Act. All that means is that while you're on probation, if you have a minor violation, like an administrative one, you miss a meeting or something, you and probation can work through that. But if it's more significant, if you get arrested for something like that, that comes back to me. I will sentence you as a first offender. Did you oppose that in any way? Do you have a position on that, Ms. Diviker? No objection? Okay. I will sentence you as a first offender. You qualify for it. And it sounds like you are sincere in wanting to turn the corner, and your criminal history shows that this isn't what you're normally up to. So we'll give you that opportunity, and I'll follow the joint recommendation of a 5-year probated sentence. You'll have 60 hours of community service. You do need to take an anti-theft course. I'm going to have you stay out of any reason you need to go to a Walmart. I know it was Walmart in Fulton.
I shop online. I don't even go if it's not the corner store, sir.
Okay.
I have no business there.
I'm gonna have you stay out of all Walmarts while you're on probation. If you end up getting a job at a Walmart, then we can amend that. But otherwise, that's you don't get to shop there anymore based on what happened. Go to Target or somewhere else. You will need to write an apology letter. You don't send that directly to Ms. Hines. Would you get that to the DA's office?
Would it go through probation usually, right?
They can go through probation. Is that something you guys handle? And then you get it to the, I guess you're handling, but the restitution is not going to Walmart. The restitution is not going to Ms. Hines. It's going to Walmart. I know you handle restitution.
Okay.
As long as the DA's office got you that. Okay, great. So you will need to write this apology letter to Ms. Hines. You'll get that to probation. You are going to also have $12,340 in restitution, which is a lot of money. You pay as you are able. It's not the case that you'll ever be locked up because you're unable to do it. But I'm making this up. But let's say you get a job that pays $4,000 a month, and you repeatedly say, I don't have any money for restitution, but you come in dressed to the nines and you're driving a Beamer, then you might get locked up because you're clearly not handing over money that you're earning. But if you can't get a job right away, or your job pays $1,000 a month and you got to take care of your kid, probation works with you and they'll say, hey, it's $50 you're going to pay each month. And so it may be that you aren't able to pay off the restitution during the time you're on probation. But if you are able, then you may be able to come off probation a little early.
Yes, sir.
All right. No contact with Ms. Hines. You'll write that one letter, but you're not sending it to her. You're getting it to probation. They'll get it to Ms. Hines. And the last thing I'm going to add, you're already doing it, but you need to get your GED. And I'm going to require that you get that GED in the first year that you are on probation. Okay. I will set a behavioral incentive date of January 29th of 2028. So that's 3 years from now. All that means is if you have done all the things you're supposed to do on probation to include that restitution, then your probation could end early. So it's a stretch goal for you, but it may be after 3 years, you're still paying down that restitution. Once you've paid it all off, then it's okay if you miss that 3-year deadline. If you pay it all off at 4 years, you're still eligible then to have your probation ended early if everything else is going smoothly.
All right.
Okay. Ms. Dilligard, anything else in connection with Mr. Banks's case?
Nope, nothing further from the state judge.
Do you have a firearms carry license?
No, sir, I do not.
All right. Ms. Rios, can someone in my office sign the indictment on your behalf?
Yes, Judge.
Ms. Dilligard?
Yes, Judge.
And okay, Mr. Banks, if someone signs it for you?
Yes, sir.
We'll do that. I think I covered everything. Ms. Simpson is from probation, and she needs to ask you a few questions about where you stay and whatnot, so she can give you reporting instructions. You'll need to, in the next few days, report to probation, okay?
All right.
All right.
I stay in Fulton County.
So you would need to report to the Atlanta office, which is 276 Memorial Drive, and I will have that address and report instructions. The date you need to report will be priority of 11.
All right.
It doesn't sit well as a pre-court.
All right.
And if you would, please, sign this. I'll take Your Honor.
Ms. Beza.
Hello.
Hello.
I have an update from Lydia Abate, if you'd like that.
Yeah, let's do that in just a sec. I'll take that. We'll figure out what we're doing next. Ms. Rios, you have some folks you need to talk to.
Yes.
If you talk to the non-custody people first, that would be great. And we'll take a quick break while you do that. And now, Ms. Beza, I'm ready for your update.
For Ryder, Lemon, and Hardy, he said that he's working on pleas for those three.
There are 4 defendants in the case. I wonder what's happening with the last one.
Probably been 4.
Okay,
I did put Ryder, Lemon, and Hardy. He didn't correct me.
that's fine.
He's working on pleas.
Good. Okay.
But his reporting instructions are based on where he is. So we can't give him reporting instructions so we know what zip code is because their reports being split off of every zip code.
That was Spence, right?
Yes. Thank you. The address is 835 Martin.
835.
Martin. Need a phone number?
Yeah, the zip code and everything.
It's not on. Let me just look it up really fast.
And yes, the telephone number. So we will send, it will be made out to Walmart.
Okay.
And then- no, I'm asking.
Oh, yes.
Okay.
And then you'd also need the victim's address for the letter.
We can, yeah.
Okay.
Because if not, you won't send it.
Yeah. Sade Hines. Her phone number.
What's the name?
Sade, it's S-A-D-E, Hines. Her phone number is 678-851-0701.
Yeah, okay. So he has to send her a letter. It's Martin Luther King Drive,
Junior Drive, MLK Junior Drive.
Okay. Okay. Okay.
30314.
30314. Do I need that store number?
Store number is 3 East,
So
3008.
East. 008.
Yes. The loss prevention manager, his name is.
Would that be who this is?
No, just in case you needed to, I don't know if you need to contact anyone directly.
We just need for wherever the restitution check needs to go to, we just need that address.
Got it.
Okay.
And then you need Ms. Hines'
Address.
address.
So we'll just have the officer to.
Will you let me know when Ms. Rios is ready with stuff? I'll come right back out. Thanks.
Her versus him that really does it. So we're not gonna do that.
So I have her address is 520 Fulton Street Southwest.
520.
Fulton Street Southwest. Atlanta, Georgia. 30312.
30312. Can I ask a question? Ms. Simpson is newer to this courtroom and taking over, but when it comes to the early termination,
Sorry, my face is like, I'm nervous for the question, because I'm also very new, but
So just wanting to know how you guys wanna move as far as like the early termination,
The incentive behavior incentive date.
yeah, for those and the others that come. So we normally give you guys like a progress report with termination, but it has to be signed by the ADA and then goes for signature. So would you guys rather her give it to you guys, or how do you?
Yeah, if the probation is recommending early termination, I say the judge says a behavioral incentive date for 3 years, like he just
Okay.
did. And probation, you're like, well, he was a perfect person for 3 years, we're recommending it, we'll go along with probation, sign it, and then give it to judge.
Okay,
Yeah.
so what about if it's not one of those behavior ones? Because after 3 years, we petition the court for termination.
Correct.
So if it's one of those that's
You can just-
not, you can still just.
Yeah,
She can
if
write
you
to
need
you.
our signature, sure, but you guys can also just petition the judge.
Oh,
We won't,
yeah.
we won't object
On there, it has a,
for the ADA signature, so we'll sign it, yeah.
okay,
Yeah.
all right. Well, I got that
We usually
information
just
for
go
you.
along with what y'all.
Gotcha,
With
gotcha.
probation, you guys are.
But yeah, they started something new where on our terminations now, we have to keep the ADA signature.
But the ADA's changed so
And then-
much.
Right, so after like 30
No one's gonna be
days-
here in 3 years.
After 30 days or so, then now we have to do a memo if we don't get anything back from the ADA. Because a while back, they gave us an email address, but nobody has
So
ever.
I would recommend going to the supervisor of whatever the case is, because like, for example, she'll probably be out of complex in a year or less, right? So the ADAs just change all the time, but the supervisors will pretty much remain consistent.
So
The
maybe-
supervisors are just on the website, so whatever, if it's like a murder case, it can be a major case, or
So when you say supervisor, we're talking about.
the supervising ADA. So like if it's a domestic violence case, in 3 years, I can assure you it's not gonna be the same ADA, but it might be me as a supervisor to sign off on it.
So how do we know that?
I would say like probably the charges, right? So murder is major case, or just send it, really just.
Well, you were probably.
Because you'll be emailing a person that probably no longer works in the office.
Well, no, we don't get no response from, it just says DA something, something, and we never, ever get an email. Nobody ever
Probably
responds
not
to that.
Yeah, I've never heard of
You're right, and that was the last thing that was given to us like a year or so ago, and from the time they gave us that, we have never gotten anything signed by us. I believe, because we never got anything, but when they first started this whole thing of having to have a ADA signature, they told us, at first they was telling us to give it to somebody, then.
So we need like a contact person in the office, because no one's gonna respond.
Yeah. So what we've been doing in the other courtrooms is, we have the officer get with the ADA.
Or just bring it to court.
That's what I'm saying, and.
Whoever's sitting here can just sign off.
Right, so that's what we've been doing.
Yeah,
like,
That's okay.
Getting a relationship with
That
the ADA,
works.
so where, if we have some, we just bring it to them.
court.
And then they'll sign, and now we're moving it forward. But yeah, we had a lot of termination orders that was just sitting there because we never had an ADA.
Yeah, it's better to just print it out and bring it on.
And then some of the judges like McBurney, he was like, no, I'm not gonna sign until we have ADA signature, so I'm like, okay.
Yeah.
But we're gonna speak with them and see how they want us to do with it.
Bring it to court.
Okay. We'll do that.
Emailing is just, it'll be lost in la la land.
I can agree. Thank you so much.
Thank you.
Okay, so,
Yeah, that's what you're
did you have a sheet for, the code? Alright, so, it's 10 days, right? Yes. These are curious. Okay. Okay, on the day of the report.
I'll make sure I can.
Alright, I'm just making sure. And I, this is my code, and I didn't have that. About this.
And I hear that too.
Yeah. Just like
I need to catch God.
Yeah, give it to him.
Because even though we really.
What stinks?
So, but, okay. Yeah, it's not all there, but it's, yeah. We used to have.
Yes, so you just remember that because a lot is actually first offender probation. I literally have your grade book, the OCGA, and read the statute. Based on the statute. Felon, because you don't have to be convicted.
What's that?
I don't know, it's on YouTube.
If they can bring it, whenever she starts, when Jay took that 3 days to come back for it. Yeah. Oh, she was supposed to get the telephone number for the Walmart.
It's like 44-460-2703.
460-2703. We're listing this time, not for the restitution. Restitution to go to, but a letter has to go to. So. We don't put a letter on it. Like, yeah, we're not putting the money there. Yeah, you just scratch that out, yes. Yeah, as a matter of fact, we can put, yeah, you know, there you go. Okay, I told somebody today, I don't know, okay, sit right on there. That's this address should not be given to him or have content.
So it says, I would say pursuant to OCGA.
He ain't sending it, I guess probation.
Which one is it? 16-11-131.
So his officer probably has to.
I would read it. Then it says read it. Any person who's on probation as a felony person, just read it, right? Or sometimes it says for felony, blah, blah, blah.
Did they say in a certain time?
So I would say, that's therefore. The statute, the plain language, the plain language of the statute. Include not only felony convictions, but a person sentenced and a first offender. Here, we have the convicted who was sentenced in blank date, blank jurisdiction, blank case number, as a first offender probation or whatever he was sentenced in for the charges. So go over, he was sentenced, you know, here we have this. This is a first offender sentence. The statute clearly says it includes first offender. Therefore, I ask for the motion to be denied. I would think that's it. That's right. That's it. 1, 2, 3, 4, 5. She's saying
It's against his constitution.
So we're not. It's good. Do you have your grade book? Yeah, these out, instead of reading on the internet, you know, they have, get the grade book and then just say, just read it for and then say, this table is really high school and the first unit for this is this, on this day, this section. Plain language, of this after school year. It includes first and second. Therefore, I asked you to deny.
My son got a game there, so I'm like, instead of going all the way back to Clayton County. It's like, but I'm not gonna go back home and then come back. That ain't even in my gas.
Okay, yeah, so.
So probably over it. It's got a fight the cheerleaders. But they just came to Forest Park. They started a whole fight with the cheerleaders. So they made our cheerleaders leave. They both of them leave. Really? So now, but here's the thing,
No,
when we,
no, absolutely not, because of the negative stuff.
when that happened,
He has a right to their rights. I'm sure he does, but not a person
that's what I'm saying.
doing like that.
So I'm sitting there like, really? Like, it's just crazy. They too have the right. That's what I'm saying.
They don't, they have unauthorized young folks who. No, I got parking lot already. During this school year. And there was a shootout.
In the school parking lot?
And I'm like,
Oh, wow.
I was like, yeah.
Yeah. Oh, yeah.
It was an unauthorized, because nobody knew.
It's good.
Nobody knew about it.
But here's the thing, so hold on, Friday, that was the day of the storm, the first day of the going back to school, after the storm. They played at Drew High School, games with the Drew. They started trouble over there. Same cheerleaders. May's cheerleaders started stuff over at Drew High School. And so they almost got fighting there. And I'm like, this is crazy. Like, at what point do y'all not sit these girls down? Like, they're out of control of what they're doing
The
now.
cash app impacts
Off.
a certification of business. Yes.
Yes. June. But I had still called her. People rang the doorbell, she still didn't go. I looked, the man walking from the door, I said, I called Mom. You know, I said, no, I didn't know the doorbell. I'm like, see. Oh, I see. But it just so happened. He didn't need a signature apparently because he left it on the door and took a picture. But it was the whole fact of if he needed a signature, she still didn't hear the doorbell. But here's the thing. I let it go on the door saying, if my package needs a signature, please ring the doorbell and give my elderly mom a chance to get to the door. You know, they're and it won't. So I said, please give my elderly mom a chance to get to the door. So he didn't run the doorbell, no, he set that stuff on there. And took off. I said,
Have your legal assistant get from the clerk's office, the certified certified, it should have a return on it, just email your legal assistant. Sometimes the clerk's office doesn't have the return on it. It's true, if your officer doesn't do the return, then it takes, because I have their certificate, that'll have their return. Yeah, this is not the, this is needed an officer to come tomorrow to bring the certificate, because I've asked him 4 times.
And he still not gave it to me, and I got the original one for shops, but I don't return, so like it's.
Amina, I asked her to. I asked her to do that. She said there's something that said it's just the house.
They might not have done the return.
Yeah, it's just.
Yeah. She said the search warrant.
People are literally going to take a package off of the. And that's why these. Showing the baby.
Yeah. But does it matter if it's not signed?
Yes, it's not signed by, if it's not signed by a judge, or it's not signed by counsel. So the way it works is. But you know what? They have like the on-call. Not like the. Right. Yeah. I've never had a issue, but if I know that I'm attracted, I have to say that in the race. I'm out of town or something, I'll come right across the street and I'm like, then they're supposed to. She'll get put in her back. We'll do that. I think it doesn't matter. But yeah, like stuff gets sit on my porch until I get home. Can nobody know about me? Present them. Or that person says, yes, okay, that's fine. You didn't get more than you're supposed to.
That's what I thought. So, nothing to me. This is for the judge will sign. So, have you talked to the
Yeah, we get.
yes, so he does. That's what I found.
So we're not gonna do it. We talked to the victim. She won.
Before my vote.
And that's fine.
I've dealt with that on
If
so
I were you to. She's fine with the recommendation. She doesn't want to be further indicted by the defendant. We also spoke to October and today. We can give a comment. First translation.
They don't want to.
I'm saying, no. Yeah, like UJR at first appearance.
Okay, I think so.
I don't know that I. Yeah. No, it's just that. You don't know how to just went home, right? But what you can do, because you know that he's had money.
I'm sorry, Mr. Chairman.
I was saying that.
I didn't see, I see the thing for her, but I didn't see a message from Spirit that that.
What it is another county. I would say this. That's fine.
So this is gonna take a while. What time is it?
And so, I'm like,
No, what time did Spirit have theirs? Thing?
Some judges want it on the record. And if they do want it on the record, I mean,
Are they daily?
some judges don't want it.
Okay, so that's not right. So Spirit has been emailing
But
Tiffany
all I really need for
confirmed times for interviews.
Okay, I used to know that I was.
And so, and I think, I mean,
Based off of that, to get instruction on record. And they get it.
Yeah, because it's very clear, like, for example, January 29th at 1 p.m. I got this person. And it's not closing on the case. You can live in right if you want because of DBR, but because he's in New Orleans, spares him. I just. Yeah, but TBS.
And that's only is correct, because you'll know whether the judge wants you to put it on record.
There's multiple. So what's happening is he's subpoenaing everybody, right? And he's setting up interviews. And for the interviews, he's setting up on Zoom. And we've asked me to whether to set up the Teams or whatever it's called. I don't know. But I sent out an invite. He's never even spoken to this junior.
He's like sitting right here, looking outside, I'm sitting right here.
She did not forward you everything she had because there are 2 emails. There's one, for example, Dickerson, and I want to say Heather Williams, in which the interview times were confirmed.
It's good for I'm supervised to come and sit and see with them. Because if they do learn something.
She never even sent you the list. This one is from, I'll send you some of it. I mean, it's really very.
You don't never step foot in.
I just sent you 2, for example, one for Heather Williams and one for investigator Dickerson. For trailer, I think you said
That's the greatest day ever because.
Trailer is 1 p.m. Thursday.
And the person
Dickerson is on Zoom. He's in Jamaica. Something. Trailer is on Zoom. I just sent you that. And then Rose, I'm doing a phone call. So far, the only Zoom, we're not Zoom teams, whatever. The only teams are Heather Williams, Dickerson, and Trailer.
talk more about it.
No, we can offer. The victim's okay with that. Get back to okay. All right.
I started with them. I was. I have a question for you.
Yes, ma'am.
Would you like Ms. Simpson to obtain, give recording instructions on the record, or how would you like?
That's a great question.
And the reason I'm asking that, because we do have some judges who don't want the, person's address to be given.
Sure,
out.
sure. And the address, I'm fine if we don't get it on the record, but it is nice to be able to say, hey, we all know you were told to report on this day at this time because it's on the record. And so maybe what we could do, either after you've confirmed that they're in County X, or maybe if you just say what counties you live in and they say X, here are your reporting instructions. That's the end of the record, and then you can get the specific address from them, and we can pivot to the next case.
That's what I just told them.
Yeah.
Because normally, now we're doing reporting instruction based off of zip codes.
Oh.
Yeah.
Because people think they're Fulton, but you punch in the zip code, it turns out, oh, that's actually DeKalb.
So that's what I was just explaining to her. I said, well, if he wants it on the record, I said, just asking them what county they live in, what zip code.
Yeah.
I said, and then by you getting that information, you already know what reporting instructions to give. So
Got
you
it.
give them reporting
Yeah.
instructions based off of that.
Sure.
And then you go out and get their physical address
Right.
versus putting it all out.
I'm fine with that.
Okay.
Great, let's try that.
Okay, sounds good.
Assuming we have any more, please.
There we go. We got 2 things here. Termination stuff. One for you.
About 6 hours.
I hope so. We had something. Can I approach you?
Pardon me? Yeah, yeah.
So, the new, with the new revocation orders,
That 4-page document, yeah.
So right now, we're on hold to get this stuff from you. So they're still doing it in anger right now.
In anger?
Ingram.
Oh, Ingram.
Ingram. They're still doing it.
Meaning using the new form.
Mhm.
Okay. How are they doing it? Are they doing it, they have a hard copy and they're handwriting it, or they have a Word version?
Right now, I think they're still handwriting it, but we're trying to get it to where, they can get it in the computer. And then I think they've been checking to see if, like, the litigation manager will be able to check on that too.
So we're working on, at a minimum, getting a PDF fillable form, for the probation folks to do it.
Because the issue that we're probably finding right now is because of the type of computer that we have.
Right, when we met with XO, she explained, you have these Chromebooks, so you can't use Microsoft Word, but you could do a PDF, but it would need to be a fillable version. And so we have someone looking at how easily we could turn that form. It's just got so many blanks. If it was just one of those address change forms, that's easy enough to create, but this is harder. But if there's a way to make it a PDF where all of the different blanks, you could edit it, and then just hit save, print, whatever, and then you've got that order.
So they're still working on that.
I'm fine using the old form for now.
So far, we haven't, because we were using Judge Ingram, as the pilot to see how it's going and what we need to do. None of the other officers of the courts have been even utilizing them at all.
Right, I'm sure there are plenty of judges who don't know it's there.
So I just wanted, because I know you asked me last Friday, right for last, were we using it and everything, but that's where we are as of today.
Okay.
Still trying to work out some things.
Okay, I'm happy to ease into it whenever you guys are ready. And like I said, if we are successful in getting it turned into a editable PDF, that'll make it easier.
Okay.
I think that is less of a struggle than saying litigation managers do it.
Yeah.
I understand the reasons for that, but it would be nice to have it all in one place, but we'll see.
Okay, and I just wanted to let
Good.
you know where.
Thank you. And you guys are welcome to pilot it here too. I mean, if you want to pilot it in more than one place, I'm all for doing that. If you want to start using the new form, I won't require that, especially if we don't have it in a, although if you're having to use the old form with handwriting as well, it's really the same concept. So I'll leave it up to you if you want to try a few with the new one, just to start learning it, because you have to use it anyway, but up to you.
I'll run that by, Chief Carlton.
Okay. Good.
I know she sent out the email earlier, we're still on hold.
Yeah.
With it.
Okay. Well, in just in case she wants another test space, we could be that.
I'll let her know.
Okay.
She needs some time to say something.
Okay.
I am ready on Lindsay and Roland.
All right, let's do some of those. Ms. Beza, you stood right up. Which one do you want to do?
We do Lindsay first, Your Honor.
All right. You're Mr. Lindsay? How are you? All right, come right on up to the microphone there, please.
did already use your first offender. Yeah, so this would be a felony. You already used your first offender, so this would be.
Let me know when you're ready.
I'm ready, Your Honor.
All right. Well, since we took a break, let's make sure we've got everyone back that we need. Ms. Rivers, you ready?
Yes, I am.
Okay. This is 24 SC 004248, State versus Thaddeus Lindsay Jr. Mr. Lindsay is here in court with his lawyer, Ms. Rios. Ms. Beza represents the state. And Mr. Lindsay, you've watched a couple pleas already today. You know how it's going to work. You'll be under oath in just a moment and be asked all sorts of questions. Answer them out loud. And if at any point you've got questions of your own, just let me or Ms. Rios know, okay?
All right.
All right. Ms. Beza.
Please raise your right hand. You swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth.
Yes.
Right? You can stand down. Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
How old are you and how far have you gone to school?
I'm 31. I graduated. I made it to 11th grade.
Are you able to read, write, and understand the English language?
Yes.
You understand that you are charged with the following offenses: count 1, aggravated assault; count 2, simple battery; and count 3, burglary.
Yes.
You understand that you have the right to either plead guilty or not guilty to these charges. And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Yes.
Have you had enough time to speak with your attorney about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes.
Do you need more time to discuss this case with your attorney?
No.
Are you satisfied with her services?
Yes.
Counsel, do you waive formal reading of the indictment?
Yes.
Counsel, do you waive any and all defects in the indictment for purposes of this plea?
Yes.
Currently, the state is unaware of any outstanding warrants related to the charges in this case. Do you or your attorney know of any outstanding warrants related to the charges?
No.
No.
Has your attorney advised you of the minimum and maximum sentence for each charge that you are pleading to?
Yes.
For counts 1 and 3, aggravated assault and burglary, the minimum is 1 year's maximum 20. And for counts 2, simple battery is a misdemeanor, minimum 1 day, maximum 12 months.
Yes.
You understand that this is a negotiated plea of guilty, which means the state is going to recommend to the court a sentence of 5 years probation, plus family violence intervention program, plus no contact with the listed victim in this case, Brytoria, Brytoria Williams.
Yes.
However, the court does not have to accept this recommendation. The court can sentence you to the maximum each charge and can run those sentences consecutively. Do you understand?
Yes.
Do you understand that if you're currently on probation or parole of any kind, your probation or parole may be revoked based on your return a guilty plea?
Yes.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes.
Are you a United States citizen?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction?
Yes.
Just as there would be from a conviction following trial. For example, your guilty plea conviction may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, the ability to obtain employment. Do you understand?
Yes.
Do you understand that you waive any of the offenses, including any mental health offenses, by entering a plea of guilty?
Yes.
Do you understand that if you went to trial, you would have the right to trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself?
Yes.
Do you understand that by pleading guilty, you are giving up the following rights? I'm going to list them. You are giving up the right to trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to assistance of counsel hired by you, or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes. Yes.
Yes?
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter guilty?
No, ma'am.
How do you plead to the charges of aggravated assault, simple battery, and burglary?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
You understand that you may only have a limited right to appeal this guilty plea conviction?
Yes.
You understand that you have 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this plea?
Yes.
Your Honor, as to Mr. Lindsay's criminal history, I see a June 2016 first offender conviction for theft by receiving stolen property and possession of a firearm, information of a felony. In addition, if this case would have gone to trial, the state would have expected its evidence to show on February 8th of 2023, officers were dispatched to 2215 Penelope Street Northwest here in Fulton County for a fight/disturbance call. Upon arrival, officers met with the victim in this case, Ms. Britoria, spelled earlier Williams. She stated that her ex-boyfriend, the defendant, climbed through her window. She didn't realize until she was opening the front door to let her son into the house that he had climbed through the window. Ms. Williams stated that once he got through the window, he had come to the front room and pushed her into a wall, leaving a hole. She stated that he grabbed her by the neck and dragged her into the couch and started choking her. Strangulation. Ms. Williams stated that she could not breathe and that the defendant had poured water on her to wake her up as she believes that she lost consciousness. She stated that when she got back consciousness, she told her youngest daughter to go to the next door neighbor's house and call the police. The victim further stated that once her daughter came back to inform her the police was called, she grabbed her belongings and left. She had pain in her neck area. We have spoken with the victim, Ms. Williams, in this case. She does not want to do a victim impact statement. We've spoken to her multiple times, including today.
She may be on the call,
She is.
which is fine, but just so you know, she's here. Okay.
She does not want to do a victim impact statement. She is agreeable to the resolution in this case. And that is all from the state.
Okay. All right. Thank you. Ms. Jackson, can you share the criminal history information you have, please?
Yes, Your Honor. He has 10 cycles. The last arrest was April the 6th, 2021 with the City of Atlanta Police Department for battery and obstruction of an officer. There was no disposition for that arrest. He does have one misdemeanor conviction. It was in 2018 out of Gwinnett County for obstruction of an officer. Nothing in addition, Your Honor.
Thank you. Ms. Williams, I heard what Ms. Beza said, which is that you don't want to make a victim impact statement. I just want to confirm that because you've waited patiently on this call for several hours now. Is there anything you want to add, or did Ms. Beza accurately represent your position on this? All right, I'm going to take that silence as assent. And I'm going to turn to you, Ms. Rios.
Yes, Your Honor. Mr. Lindsay is 31 years old. He's from Atlanta. He has one son that's 10 years old, and he has a child on the way. His fiance is here in support. She's pregnant, and they plan on moving to Tennessee to start over. We talk about how the transfer will work with probation, and he's ready to put all this behind him. And so I'm asking that to accept the plea as negotiated to the 5 years probation.
The son that Mr. Lindsay has is not with Ms. Williams, is it? No? Okay, so someone different. Some point in time, you and Ms. Williams were an item. You're not anymore. You were never an item?
We was together.
Okay. I mean, you were together. We use whatever words you want. You're not anymore. And now you're in a relationship with someone who is with whom you'll have another kid.
Yes.
Boy or girl, do you know yet?
She says a girl.
You think she's making it up?
It's a girl, Your Honor.
I trust you. Okay. Mr. Lindsay, do you have any questions about anything anyone has discussed?
No.
Okay. Anything you want to add?
No, I just want to get this behind me. I'm trying to start over. I was young. I was like 28, 29 when I think this happened.
Okay, that's not so young, but younger than you are now. Why moving to Tennessee?
I just want to start over. Like, I've been out here for almost 30 years. Like, I feel like it might be a little more better chances out there for me than down here.
Where Tennessee's a long state. Where in Tennessee would you go?
Gallatin, is it? I don't know how to say it.
I don't know.
I don't know how to say it, but she know.
Oh, Gatlin. Yes. Okay. Does the mother of your child have a connection to Gatlin, or what about that? That's just you looked at pictures of it and you say that's the place for us.
Yeah.
Okay. Well, good luck with that. We got to talk about that some more in a moment. But I do find, Mr. Lindsay, that there's a factual basis for your plea. Something happened in February of 23 where you lost it, and it may be that there was some back and forth, but you did some things you shouldn't, and you hurt and scared someone who at one point was important in your life. I also find that your plea is knowing and voluntary. That just means you've understood what we talked about. No one's forcing you to enter this plea. I'm sentencing you pursuant to the Probation Options Management Act, which means that while you're on probation, which you will be for a little while, if you have what we call a technical violation, you and probation can work through that. That doesn't have to come back to me. But if it's more serious than that, then we'll have to have a conversation about whatever happened while you were on probation.
I promise you won't have any problems out of me after this.
All right. If I had $1 for every time someone promised me that, I would be rich. But here I am, a public servant. Mr. Lindsay, do you have a weapons carry license?
No, sir.
You understand that this will be a conviction. It sounds like in the past you were able to take first offender and you did that well, and that kind of got wiped off your record. There's no wiping this off your record. It's a conviction. And so if you're in Gatlin looking for a job and they say, are you a convicted felon? If you're being honest, you're going to say, yes, I am. You understand that?
Oh, definitely.
Okay. I'm going to sentence you on count 1 to 5 years to serve 2 months with the balance probated. Count 2 is going to be 2 months to serve. And count 3 will be 5 years to serve 2 months with the balance probated. Those will all run concurrently with each other, meaning at the same time. You'll get credit for the time you serve, which is just a little bit more than 2 months. So you're not at this point going back into custody. Special condition of probation number 1 is that you leave Ms. Williams alone. Sounds like you've been doing that for a while, but you don't call her, you don't write her, you don't post something on your page or gram or whatever it is saying, Victoria, I'm sorry, or I can't believe you did this to nothing. So if you have been doing well at that, continue to do well at that. Second, you'll need to complete what's called a family violence intervention program. Now, that's not just one class, so that's going to make this move a little complicated, but we'll talk about the move in a minute. But that's the other special condition of your probation is do these classes, and as long as you're on probation, you're not having any contact with Ms. Williams. Now, you are free to move to any state that will accept supervision of your probation. Your charges, while very serious to Ms. Williams and to maybe those who are following this, they're very transferable. So you're not going to run into a state, you're not a child molester. We're like, I don't want to supervise this guy. But it's still an administrative process. So it's not that you call your probation officer, hey, I'm moving to Gatlin or Gatlinburg, wherever you're going. There's actually paperwork you fill out, and Tennessee has to say, great, we'll take Mr. Lindsay. So don't go buy a house in Tennessee and move without coordinating it with probation. Take care of the paperwork first, which means, and it doesn't sound like you were leaving tomorrow anyway.
I was trying to leave somewhere.
Well, it ain't gonna be tomorrow because you got to get situated, and like I said, there's this administrative paperwork process, and it doesn't take forever, but it doesn't take one day, and it's not until probation here says you're good to go, you can be supervised in Tennessee. There's actually a handoff, so you know, oh, I report to the probation office in Chattanooga or wherever it would be, and then that supervision is handed over. Okay. And probation can tell you how it works. It's not meant to be a mystery, but they may hand you a stack of papers you have to fill out. You got to spend some money on it and whatnot to get the supervision transferred. Ms. Dilligard, Ms. Beza, can someone in my office sign the indictment on your behalf?
Yes, Your Honor.
Did you have anything else you wanted to add to the conditions of probation?
No, Your Honor.
All right. Ms. Rios, can someone in my office sign the indictment for you?
Yes, sir.
And can we sign it for you, Mr. Lindsay? Sign the indictment indicating your guilty plea.
Yeah.
Yes? Okay. Then we are done, other than that you need to get reporting instructions from probation. What zip code do you stay at right now?
I think it's 30314.
30314. Do you stay with the young lady who's here?
No, I'm actually from place to place.
You're what?
I say I'm from place to place. That's why I was finna move.
Okay. Well, what's the most?
I don't have a stable home here.
No. Okay. What's the most stable address for you? Is that the 30314?
Yeah.
Okay. All right. That's Fulton County. So we're going to get you reporting instructions on the record, and then you're going to give whatever address is the best address for you off the record to Ms. Simpson, and you'll need to take it from there.
All right, so Mr. Lindsay, your reporting date will be February the 11th. That is on a Tuesday, and you must report to the 276 Memorial Drive that is here in Atlanta. It is literally about 5 minutes from here. You must report at 8 a.m.
All right.
Okay.
Will he get that in writing from you, or should Ms. Rios write that down?
Once I get your address.
Great. So that'll close out the record here. You're going to step outside with Ms. Simpson, give her your best contact information. Hopefully you have a phone number that's stable. Even if you,
I got a phone number.
even if your address isn't super stable, you want to give her the best one. Probably give her contact information for the mother of your child, because maybe that's more stable, all that kind of stuff. Don't miss your first date, because if you miss that reporting date, they just bring me a warrant, and everyone's going to be a lot less interested in saying, go ahead to go to Tennessee if you aren't taking care of business with probation.
Right.
Okay. Are you working right now?
Just the problem, I'm trying to wait till I get down there. Like she actually just came back. She ain't been out here like 2 days.
She being the young lady sitting right here.
Yes.
What's her last name?
Nelson.
Nelson. Ms. Nelson is from Tennessee?
No, she from New Orleans.
From New Orleans?
Yeah.
Yes, sir.
Okay, but you're not going to New Orleans, you're going to Tennessee.
Tennessee.
Okay, and you're saying Ms. Nelson just came from New Orleans?
She been out here like a day and a half now, right now.
And within the 2 days, you guys had a kid?
No, we've been dealing with each other. I used to work with her. I used to work with her at Burger King on MLK.
And then Ms. Nelson went to New Orleans?
Yeah.
And has decided to come back for you?
Yeah, time got rough, and we just split ways.
Okay.
And she back now. I've supposed to been leaving, but I guess it
can take a little bit, because your reporting date's not till February, so you obviously can't go anywhere before then. And then you can work with probation about getting things transferred to Tennessee.
You're right.
All right. You do have something else.
Yes, Your Honor. I just received a message from my victim advocate, and Ms. Williams would like to say something to the court.
Okay. Ms. Williams, good afternoon. If you'll unmute, I'm going to get you on the screen here, and I would like to hear from you if there's something you want to add. Whoops, it's still muted. I don't know what button you need to press, but we can't hear you from our end.
I think she said she can't hear.
Your Honor, she's saying this is the victim advocate. She's saying that she's having a hard time unmuting herself.
Okay. So I don't know if she could call you, or if she wants to, let me see. I can't.
If you can give me a second, let me speak with her. It seems as if she wants to speak to me to tell me something.
Okay.
So if you'll give me a moment, let me speak with her briefly.
Sure.
Okay, thank you.
Happy to do that. You guys can have the conversation about getting his information. If you just do it back by Deputy Gordon, that way if Ms. Williams does pop back on, I want to make sure Mr. Lindsay's able to hear it. Okay. What are we doing next?
Quentin Rowland.
Well, that's next, and that's Ms. Beza. All right.
My last date is after 5.
After 5, I hope we don't go that long.
I have to go to the date.
All right.
I just told my mother-in-law she has to get my son.
But I don't think it's. Okay.
All right, we're gonna wait 1 second just in case. And who is it? Who is the victim advocate? Is that Sandra Jean-Louis? Okay.
Yes, sir, I am.
Hey, great.
I need less of my cases on one day. It's too much.
It's odd the way it's flowed because Ms. Wood has a bunch on that trial calendar. You have less. And then you've got all these, which would flow to the trial calendar, but I guess you're resolving a bunch now.
Yeah.
I do have what you would like for your honor to know.
Oh, okay.
For the record.
Hold on 1 sec. Let's get, hey, Mr. Lindsay.
Is she back here for a second?
Yeah, we just need Mr. Lindsay for 1 second so he can hear this. We're going to close out the record in Mr. Lindsay's case. So Ms. Williams was having technical difficulties, but she was able to relay to the victim advocate, who in turn has relayed it to the prosecutor, what Ms. Williams wanted to add.
Ms. Beza, would you please speak into the microphone, please?
Yes. Ms. Williams wanted the judge to know that she stated that Mr. Lindsay jumped on her last week. And so if your honor can emphasize that there's to be absolutely no contact, she is agreeable with the disposition, but she wanted to be emphasized that there should be no contact. She states that's why he has bruises or scratches to his face. I'm not here to, and that she wanted the honor to know that.
Okay. I don't want to get in the middle of any situation, so I'll explain it real clearly. And you seem like a savvy guy, so I think you'll pick up on this. The quickest way to have all of your probation revoked and turned into prison time would be for you to have any contact with Ms. Williams. I'm not saying you did. I'm saying you better not from this moment forward. So if Ms. Williams is able to produce evidence, video, this or that, that occurred after 4:10 p.m. on the 28th, that you're in her face, you're talking to her on the phone or anything like that, that will end your probation in a way that will make Tennessee seem very far away. But if you aren't having any contact with her, easy peasy. So I don't want to get in the middle of what's going on. I want Ms. Williams to be able to move forward in her life peacefully. I would love for you and Ms. Nelson to start something new somewhere in Tennessee. So just understand that short of like robbing a bank, the quickest way to have all your probation turn into prison time would be to have any contact, jumping her, not jumping her, Ms. Williams. Understand? Yes? I figured you did. All right. Thank you.
You're welcome.
Thank you, Ms. Williams, for being on the call. And we're going to turn to Mr. Rowland now. Sorry, Mr. Rowland, for the yo-yo up and back here.
No problem.
You ready?
Yep.
Okay. This is 24 SC 004-249, State versus Quentin Rowland. Mr. Rowland is here in court with Ms. Rios. Ms. Beza is the prosecutor on the case. Mr. Rowland, you're going to be put under oath in just a moment. Ms. Beza is going to ask you a bunch of questions about you and your case and your rights. Please answer those questions truthfully and let Ms. Rios or me know if you've got any questions of your own, okay? Thanks.
May you please raise your right hand? Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
You may put your hand down. Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
How old are you and how far have you gone in school?
12th grade, 49.
Are you able to read, write, and understand the English language?
Yes.
Do you understand that you are charged with the following offense, which is aggravated assault strangulation?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to our negotiated plea, which is a reduction to battery, family violence, misdemeanor? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you had enough time to speak with your attorney about all the facts and circumstances known to you regarding the negotiated charge in this indictment, including any potential defenses?
Yes.
Do you need more time to discuss this with your attorney?
No.
Are you satisfied with her services?
Yes.
Counsel, do you waive formal reading of the indictment?
Yes.
Counsel, do you waive any and all defects in the indictment for purposes of this plea?
Yes.
Currently, the state is unaware of any outstanding warrants related to this charge. Do you or your attorney know of any outstanding warrants that are related to this charge? Has your attorney advised you of the minimum and maximum sentence for the charge that you are pleading to?
Yes.
As this is a misdemeanor, the minimum is 1 day and the maximum is 12 months.
Yes.
Do you understand that this is a negotiated plea of guilty, which means the state will recommend a sentence to the court of 6 months probation, plus while on probation, you are to do the family violence intervention program and to have no violent contact with the listed victim in this case, Elgia Rowland, Elgia Rowland. You understand that that is a negotiated plea?
Yes. I'm sorry. When you say contact, what you mean?
No violent contact, which is illegal anyway. You can't
Okay,
make her-
okay. Yes.
But
And just so you may already know this, I believe Ms. Rowland is on the call.
Yes, Your Honor. she
Okay,
is.
great.
Do you understand that the court does not have to accept this negotiated plea, that the court can sentence you to the maximum on each charge, on the charge?
Yes.
Do you understand that if you are currently on probation or parole of any kind, your probation or parole may be revoked based on you entering a guilty plea?
Yes.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes.
Are you a United States citizen?
Yes.
Now, do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea conviction may affect the right to vote, right to hold public office, right to serve on a jury, right to obtain a passport, right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
You understand that if you went to trial, you would have the right to trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself.
Yes.
You understand that by pleading guilty, you are giving up the following rights: the right to trial by jury, the right to remain silent and not to incriminate yourself, the right to confront witnesses against you, the right to assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges at a trial.
Yes.
Has anyone forced you, threatened you, or promised you anything to get you to enter a guilty plea?
No.
How do you plead to the reduced charge of misdemeanor battery family violence?
Guilty under Alfred.
Okay. Are you pleading guilty because you have decided that it is in your best interest to do so?
Yes.
Are you aware that even if you do not admit to guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at a trial?
Yes.
Is this guilty plea freely and voluntarily given with full knowledge of the charge against you?
Yes.
Do you understand that you may only have a limited right to appeal this guilty plea conviction?
Yes.
You understand that as this is a misdemeanor charge, you have 12 months from today to file a habeas corpus petition challenging the voluntariness of this plea.
Yes.
And if this case would have gone to trial, the state would have expected its evidence to show that on January 21st of 2022, at approximately 2:56 p.m., the defendant and his wife, Ms. Elgia Rowland, got into a verbal dispute. The defendant then strangled his wife, Elgia Rowland, with his two hands, leaving red visible bruising around her neck and visible scratches on her left cheek. Officers were called and made notation of these injuries. Ms. Rowland is on the Zoom today. Ms. Rowland is agreeable and actually on board with this position that we're offering. And Ms. Rowland would like no violent contact as opposed to straight no contact. I do believe they're still together. My understanding that she does not want to make a victim impact statement, but that could change.
Okay, well, let me ask, Ms. Rowland, is there anything you want to add, or has Ms. Beza accurately conveyed your sentiments about this situation? She's not looking like she's gonna unmute. Ms. Jean-Louis, any? Oh.
I'm sorry, I didn't know I had the mute on when I was talking. Farrell, calm down, sweetheart. I just want him to get the help he needs, just so he can be a better person for a better outcome in our relationship.
Okay, thank you.
Yeah, 337.
Well, there you have it. Let me hear from Ms. Jackson, please.
He has 7 cycles. The last arrest was September the 30th, 2018 out of College Park, Georgia for simple battery. That charge was dismissed on February the 22nd, 2019. He does have prior felony convictions, one in 1996 for theft by receiving stolen property. And there was an additional one in 1996 for burglary. He has one misdemeanor sentence. He received first offender treatment in 1992 out of Cobb County for theft by taking. That case was sealed March the 10th, 1992. Nothing in addition, Your Honor.
Thank you. Ms. Rios.
Yes, Your Honor. Mr. Rowland is 49 years old. He lives with his wife and 7 children. Right now, he is a writer. He's working on his books about pyramids. And so we're asking for you to accept the plea as negotiated. It seems like everyone is on board with the resolution.
Mr. Rowland, you have 7 kids in your household.
Yes.
What's the age range? One of them is clearly very young.
Yes, from 4 months to 24.
So the adult children live in the household as well?
Yes.
How many bedrooms is the house?
4 bedrooms.
Okay. Any reason the adult children are still in the house?
Special needs.
How many are over 18?
3. One birthday was yesterday.
Just turned 18?
Yeah.
Okay. And all 3 are special needs, or the 24-year-old is?
The 24 and the 22.
Okay. 18-year-old is in high school?
Yes.
Where?
Tri-City High School.
Okay. What are the plans after high school?
Either military or college.
Okay, those are different choices. And you are a writer. That doesn't always put food on the table. Do you have a backup job as well, or you are a successful enough writer that it does put money on the table?
I do. I also work at like a convenience store.
What do you do there?
Cashier.
How many hours a week?
Probably about 24 hours.
Okay. And you're married?
Yes.
Does your wife work outside the home?
Yes.
Doing what?
She works in the deli at Walmart.
And do your schedules align so that someone's always home with the littlest ones?
Yes.
Got it. Okay. Do you have anything you want to add or any questions about anything?
I just, as for the mercy of the court, we have resolved this. We've been together for a long time, and I got a new baby girl. It's my first girl, and I just want to spoil my girl.
Is 7 the magic number, or is there going to be 8 and 9 and 10?
Well, it's 8 total, but 7's at the house.
Okay.
But I have an outside adult, from a previous relationship.
Okay, but for you and Ms. Rowland, is 7 where we're stopping, or?
Yes, most definitely. I have my girl.
Okay, so it's just pushing to get the girl. All right, well, I find there's a factual basis for your plea. In January, 2 years ago, we're almost at the 2-year anniversary in 3 days of whatever went wrong. You treated your wife in the wrong way in all sorts of ways, and that's something that needs to not happen again. Doesn't mean you guys can't argue about things. You've got 7 kids in the house. You're going to argue about things. You need to govern yourself accordingly. And if you feel like you're getting hot about something, you walk away, or do something other than what happened in January of 2022. I find that your plea is knowing and voluntary. And I will follow the negotiated resolution and sentence you to 6 months probation, with the lone count of your indictment being reduced to family violence battery. You should know, and Ms. Rios probably already told you that if you ever pick up another family violence battery, it's a felony. You get 1 misdemeanor. Doesn't even have to be the same victim. So if you put your hands the wrong way on your 24-year-old, that is a member of your household, that's family violence battery, that will be a felony. And you've already used first offender, so that'll complicate things. It's just a reason to be particularly thoughtful about how you manage your familial relationships. You have a crowded house, 4 bedrooms and 9 people. That's not good math. So it's going to be complicated, and I hope you're thoughtful about it. 2 special conditions of your probation. Number 1, the most important one, is no violent contact with Ms. Rowland. You can be around her. Obviously, she's your wife and you live in the same household, but that contact needs to be peaceful contact that she wants, not contact that you inflict on her. And second, you need to complete a family violence intervention program. And that's not 1 class, it's a series of classes. In fact, 6 months is going to be pretty tight if that's all you have for probation. So I'm going to require that you enroll in that family violence intervention program within the first month of your probation, so that you've got a chance of wrapping it up before your probation is over. Ms. Rios, can someone in my office sign the indictment for you?
Yes.
Ms. Beza?
Yes, Your Honor.
And Mr. Rowland, can someone in my office sign the indictment on your behalf indicating your misdemeanor plea?
Yes.
We'll do that. Anything else, Ms. Beza?
No, Your Honor.
Ms. Rios?
No, Your Honor.
All right. Are you done with the book on pyramids, or you're working on the book on pyramids?
Almost done. I have the whole concept down. So it's something that's never been out there before.
Good. Well, good luck with that. Hope it works out. You will get reporting instructions probably through Ms. Rios. That may have been why you were writing that stuff down, so she knew how to contact you. But misdemeanor probation is run by a different organization than the folks here from DCS. Okay?
Okay.
Any questions?
No.
Okay.
I appreciate it.
Text you their contact information, but I have.
Good luck, Ms. Rowland, with everything.
Okay.
You put the number? What's the number?
Yeah, I don't forgot her.
Okay, go
last
get it and then just leave it on my desk or give it to the deputy.
Okay.
Just go, take the pen, grab the paper, and just write a number.
All right, Ms. Rios, what's next? You need a break?
No, we don't need a break. I'm gonna go back and we're going to figure out what is going. Likely, we'll have only 1 more plea.
Okay. Ma'am, who are you here for? You're the only person sitting back there. Okay, so we'll be sure to cover that. That's just a bond hearing. It sounds like his case may get more complicated if it goes federally. But you'll let us know about the other folks who are back there, Ms. Rios. Okay. Ms. Beza, you have still Burwell. Is that your last case for today?
Yes, Your Honor.
Okay. All right.
And 88 Hillsborough has agreed to cover it.
If you have to leave to get to daycare.
Yes.
All right. Oh, yeah, I meant to ask, we don't do a lot of revocations like that where there's a full-blown hearing. Do I do the order, or it sounds like you do the order? I mean, you heard me say it's 10 years. All right, I like that. It was pretty fascinating watching that stuff on video. I can't believe they shot that guy.
Yeah.
Green Hat is who they really need to get. And they just got, this is like the middle of the day, and two guys hop out of the car with guns. And they're just, I mean, it was like 2 minutes that this lasted. The car's driving by, like, hey, look, he's got an assault rifle. Yeah. 2 blocks from Morehouse. And the high-speed chase was interesting too. He had a busy couple days, that guy.
Inside the sewer. That's the part I got thinking. I was like, okay.
Like, are there snakes in there?
Okay, let's hide in the sewer. Okay. He was just trying to get away. He didn't even care.
No. He might have, but he had to spend all his time pulling up his pants. I don't know if you saw that, but he jumped out of the car and he couldn't run right away. Officer was huffing after him.
When you did catch up with it. At that point, I come out the sewer. That's why I was like, at that point, I knew he was mad.
But it's one of the beauties of body cams. He may have been very mad and he was able to verbally express his disappointment. And that's as far as it went.
Yeah.
And that's better.
When that part came, the officer was like,
Oh, when he heard himself say
when
it,
he
yeah.
heard himself say that, he's like, he started shaking his head like,
Yeah.
at that point, he was out of breath. This information is going to stay. Yeah, your attorney should give you they're gonna get it.
Other information come up? Yes. So, you're right.
I can explain to you. Yeah, so, he's got his father. I saw that too. And I remember that. No, I remember that. Correct, we did that. Just like whatever it ever was, a message that related to his name, so it's not actually.
There you go.
Yeah.
So, thank you. I'll be right back.
That 2 years starts with probation, so then sentence and serves the time. You can't count the time you spend. It's probation start. So for example, let's use this guy for example. Let's just say we would use his probation start date because if he had served any time, His probation start date would be once he graduates. You have to be mentally, so, and I'm just saying that's what's the case, yeah. So, that probation start date, based on this, 2 years, so, against probation start date. That's all we had, it's the case. And he didn't get a plea because all that out the door when they get a plea. So it don't do that. But if it's just a revocation, no new cases coming, get that. No, the revocation. Oh, yeah. He don't know what he got on his home, but yeah. If you're yeah, if it's still we would have told the judge, this is the next means
Would you be able to take the last state permission? I didn't know
because it's but you have to bring it to see all that conversation.
No, Peachtree, the officers were at my phone and went to Peachtree. You wanna see it? Yeah.
Especially when no restitution. They can only fines.
I don't have a lot of that by receiving stolen property. That was 220. What is that? I don't either.
Come on, we don't have that, but then I don't.
Let's just get them in.
Yeah, somebody's one. This is
perfect. Okay.
This is these two negotiated and that's like under probation.
When you want hybrid, like these two, like regular second minute changes, because we got those as my right.
You add these two together and supervision. Cause these are $23 plus the minimum. They're just covering DV cases or is this children covering
the Jasmine's school?
And this children come bigger than merciful.
The courtrooms.
The probation.
Jenny was like still helping.
It's so strong now. And when I add those two together, just two supervision, and it was 32. So I have this, which is speaking. If they're you say $32, but we're saying, we're saying that to include children accommodation, nursing,
When I'm supposed to do it to change.
next week, the person's supposed to be starting on Monday.
The new person that totally ran into the office.
Yes.
So really it's not really next week because they're gonna help.
Well,
I mean, I don't know.
if it's not taken seriously,
Oh,
the institution, so,
then I'll honestly,
hopefully it'll be a smooth transition. And there's nothing called good transition. And you know, I just never received one or two, and all of them.
Right.
That's the very case. But, that would keep an indictment number school for like, for SC, like 2,000 to like 6,000. Because she just wasn't sure cases for once.
Oh, because she was the judge over.
And the judge put that,
I'm gonna ask if I can be excused. I'm ready to excuse.
Your coverage is gone. Yes. All right. Yes, ma'am. Go do the childcare thing.
How long is it gonna take?
McBurney always drives us like slaves, so.
Yeah.
Been here till after 5. Oh.
Not at all.
Not say anything, but I think if I want to make a statement, I think we can online. She says she doesn't care about his face.
Folks have been real quiet back in lockup. I guess it's just they're patient. It's not a rowdy crowd.
Bye, Judge. Thank you.
See you. Thanks for your help. So you are basically Ms. Willingham for the foreseeable future.
Yes.
Okay.
So, Madam said that someone will be starting a DB hopefully by mid-February, someone outside the office coming in.
Okay.
Don't know that person.
Interesting. Okay.
They have a bunch of new hires, so hopefully they get onboarded soon.
Good. And then that person would necessarily be here, or that just allows you to shuffle the chairs around a little?
Shuffle the chairs around.
Okay.
I don't know about the new person in this courtroom, but
Okay. All right.
I don't want her to be a request to this courtroom. She said she's practice in front of you, so.
Uh-oh. Sounds good.
Nope.
Bye.
Is it spinning it out into the supervised, yeah, but they're comfortable. The first committee, and I'm not sure, and I had other ones, but we don't say anything to extend it out. So you don't do it. So when you're doing it, you always want to look and see if it's in their sentence. If they say that he's not doing unsupervised, and then you want to check the revocation cases at any point.
I think so. She said one plea and then we have a bond hearing. But there's more than one position. So I think there'll be there more than 2 positions. So there may be a final plea. So we have Tiller and Burwell and Rogers. So 3 left. Rogers is just a bond hearing. So one of them is a plea and one of them is it's not looking out, I guess. Is that what, don't you have those same 3? Yeah. Ms. Rios is back there. I'll get Deputy Gordon to get her in just a sec. I'm signing one of the final dispositions. Oh, your pressure. Yeah.
That's what they take. Yeah. I mean, it's
She ready?
Yes.
All right.
We're well.
Which way y'all taking for?
So we're gonna do Mr. Burwell, we'll do a bond hearing on Mr. Rogers, and then Tiller.
That's a plea.
It is a plea.
Mhm.
Look at you,
I know.
lemonade. All right. Ms. Rivers, you still with us?
Yes, I am.
All right, looks like OT for everyone today. This is position 8, 24 SC 004278. I'm going to speak slowly so we can let Ms. Dilligard make it up there. And that's all right. It's State versus Nicholas Burwell. Mr. Burwell is here in court with Ms. Rios. And I had Ms. Beza's name listed here, but you're covering. You're good? Okay, she did have to run. We have Ms. Dilligard for the state. Mr. Burwell, Ms. Rios tells me you're prepared to enter a plea in your case. Is that correct?
Yes, Your Honor.
Okay, you don't have to bend into the microphone. You just have to be a little closer to it. That's all right. They'll be able to hear you. Ms. Dilligard is going to put you under oath in just a moment, ask you a bunch of questions. You need to answer those questions truthfully. And you also need to let me know if you've got questions of your own. I need to be comfortable that you're following what's going on. So if someone says something that doesn't make sense or it's going differently than you thought, let me know, okay? Yes?
Yes.
Okay. And whatever your answers are, make sure that you verbalize them. So you can nod your head to these questions, but also say yes or no or whatever your answer is.
Yes, Your Honor.
Great. All right, Ms. Dilligard.
Mr. Burwell, please raise your right hand to your best of your ability. Do you swear or affirm that any statements or testimony that you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
You can lower your hand. Please state your true, correct, and legal name for the record.
Nicholas Edward Burwell.
Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No.
Is there any medication that you normally take that you have not been given today?
No.
How old are you?
27.
How far did you go in school?
GED.
Again?
GED.
Do you understand that you've been charged with the following offense? Count 1 is aggravated assault. Count 2, robbery by sudden snatching. Count 3, criminal damage to property in the second degree. Count 4, theft by receiving stolen property. Count 5, possession of a firearm during commission of a felony. And count 6, obtaining unlawful entry to MARTA.
Yes.
You understand that you have the right to plead either guilty or not guilty to these charges?
Yes.
Do you understand that if you plead not guilty or remain silent and refuse to enter any plea at all, then the state is required to prove the charges against you at a jury trial?
Yes.
Have you had the opportunity to review the waiver of rights form with your attorney?
Yes.
Have you had enough time to speak with your lawyer about all of the charges in this indictment, including the facts and circumstances relating to them?
Yes.
Would you like any more time to discuss this case with your lawyer?
No.
Are you satisfied with your lawyer services?
Yes.
Counsel, do you waive formal reading of the indictment for purposes of the plea?
Yes.
And do you waive any and all defects?
Yes.
The state is unaware of any outstanding warrants related to these charges. Do you remember having been arrested on these charges?
Yes.
Has your attorney advised you at the minimum and maximum sentence for each charge to which you're pleading guilty today? I'll go over them and make sure that you understand as well. Count 1, aggravated assault, the range is 1 to 20 years. For robbery for sudden snatching, it's 1 to 20 years. Criminal damage to property in the second is 1 to 5 years. Theft by receiving stolen property, 1 to 20 years, question mark?
10 years.
10, okay. 1 to 10. Possession of firearm during commission of a felony is 5 years consecutive. And obtaining unlawful entry to MARTA is 1 day to 12 months. Is that your understanding?
Yes.
Do you understand that today you are entering a negotiated plea of guilty, which means the state will recommend the following sentence to the court? Looks like the negotiation is to plead to the indictment plus drug court plus 5 years probation and also a family violence intervention program and no contact with the victim. Is that your understanding?
The 5 years, the gun charge has to be suspended, so then it's a 5 years suspended after that.
So I want to interject for a moment. Drug court's great if he's been accepted into drug court. These are some pretty hairy charges for drug court.
Yes, the order was sent to Ms. Nelson. It's already been, the agreement has already been signed and the order has been sent to Ms. Nelson.
Okay, this would have been very recently that it was sent to Ms. Nelson?
Yes, it was sent to her today.
Okay. Drug court has obviously interviewed Mr. Burwell, the most important part, but also reviewed his charges.
Yes, they accepted him. So
Okay.
I believe they.
Then point two, having family violence intervention program be a condition of probation while he's in drug court is problematic.
Okay.
I don't know that they can overlap perfectly. I think we'll add that as a condition, but I reserve the right to strike it as a condition if the folks in drug court say that's too intensive, simply meaning he doesn't have enough hours in the day. There are plenty of people who go through drug court, and in particular BHTC, who also do anger management, and this is of that family. So it may work out just fine, but I want Ms. Dilligard to know that it might be that either we defer family violence intervention program till after drug court, or we just actually have to strike that as a condition because it conflicts scheduling wise with drug court.
Yes.
Okay. Great. So the structure of the sentence was 5 years probation plus 5 years suspended.
Yes, Your Honor.
Got it.
For the possession of firearms during commission of a felony.
Yep. All right. Sorry for the interruption.
Do you understand, Mr. Burwell, that the court is not required to accept the state's recommended sentence?
Yes.
And do you understand that the court has the right to sentence you to the maximum possible sentence on each charge?
Yes.
Do you understand that if multiple charges to which you're pleading guilty today, that the court also has the right to run those sentences consecutively?
Yes.
Do you understand that if the court decides to order a sentence that differs from the negotiated plea that you were expecting today, you have the right to withdraw your plea of guilty?
Yes.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on your entering of a guilty plea today?
Yes.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
Yes.
Do you understand that if you're on probation, you must follow all the special conditions of your probation?
Yes.
Do you understand that if you fail to follow all the special conditions of your probation, then you'll be subject to revocation of that probation for the balance of your sentence?
Yes.
Do you understand that you're not allowed to possess or use a firearm while on probation?
Yes.
Are you a United States citizen?
Yes.
Do you understand that by pleading guilty to a felony? Oh, I'm sorry, I did that already. Is this first offender, Ms. Rios?
No.
Okay. Do you understand that by entering a plea of guilty, you are waiving any and all defenses, including any mental health defenses?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to the assistance of counsel, the right to the presumption of innocence, and the right to appeal if convicted of these charges at a trial?
Yes.
Is it your decision to waive these rights and enter a guilty plea today?
Say that again, repeat that.
Is it your decision to waive these rights and enter a guilty plea today?
Waive
the rights that she just read, like how I read you the rights in the back, you're waiving them because you're entering a plea.
Yes, yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is your decision to enter a guilty plea because you are in fact guilty?
Yes.
Mr. Burwell, how do you plead to the charges of aggravated assault, robbery by sudden snatching, criminal damage to property in the second degree, theft by receiving stolen property, possession of a firearm during commission of a felony, and obtaining unlawful entry to Martin?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
You understand that you only have a limited right to appeal this guilty plea conviction?
Yes.
You understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition.
Yes.
You understand that for a felony charge, you only have 4 years from today to file a habeas corpus petition.
Yes.
And for a misdemeanor charge, you only have 12 months from today to file a habeas corpus petition.
Yes.
Judge, if this case were to proceed to trial, the state would be able to prove that on May 16th, 2024, at approximately 1:47, while patrolling the MARTA 5-Point Station in Fulton County, a call came out in reference to a female later identified as Tamaya Durden being shot at by a male identified as the defendant Nicholas Burwell at the Peachtree Center Station. Officers interviewed Ms. Durden, who stated that the defendant was mad because she wanted to leave. That's when he started hitting her, which led to him taking and breaking her cell phone. Then Burwell pulled a gun and shot at her on the platform. He then departed up the stairs and started to harass other male patrons. The firearm ended up being a stolen firearm registered to Zachary Addison. Judge, also the victim was contacted and agrees with the resolution. Deputy Besa put here, the victim does not care about the case and wishes to move on with her life.
I know you're filling in, but the fact that Ms. Beza had the case, is there some, and Ms. Rios may be able to answer this, relationship between Ms. Durden, or was there, and Mr. Burwell?
There was.
It's not a stranger on stranger
They were together.
taking the phone and throwing it on the MARTA tracks. Okay. Got it. Ms. Jackson, criminal history information, please, on Mr. Burwell.
He has 8 cycles. The last arrest was February the 6th, 2024, out of Clayton County for a probation violation. The underlying charge was false imprisonment. There was no disposition for that, but he was originally arrested on June the 19th, 2023, out of Clayton County for false imprisonment and battery. Something happened because he was on probation in 2024. Nothing in addition, Your Honor.
Thank you.
Judge, he doesn't know the violation for the probation case.
There is a probation warrant. Okay. All right. We'll work through that. So they need to see Mr. Burwell down in Clayton County. Okay. We'll still work through what we're going to do here. Ms. Rios.
Yes, right. Mr. Burwell is 27 years old. He's from Georgia. He does not have any children. He did obtain his GED prior to being arrested. He was working at Amazon and Stoner's Pizza. He does have a serious drug addiction. He's been addicted to Percocet since he's 18 years old. He also has some severe mental health. When I referred him, I thought that they were actually going to do mental health court, but they said drug court was more appropriate. We were asking that you accept the plea as negotiated. He was going through a lot around that time and was basically having an episode. So in regards to, I guess we'll talk about this later, but in regards to the hold, because there was not a hold in the system for Clayton County initially, and he was having questions about how he would get to drug court since he's been accepted. I'm not sure if he would go there and then they send him back and then drug court takes him. I haven't had this situation before.
We'll work through that, but that's not uncommon where someone's accepted into drug court, but they have a foreign hold. So Clayton would be foreign. Just go resolve that. So we'll put a drug court hold on Mr. Burwell. So he'd go to Clayton, brought back to Fulton, and then at the next available orientation, which is every Tuesday, he'd then get picked up by drug court folks, get that orientation. If he needs housing, we've got supportive housing for 90 days-ish, all that kind of stuff. So I won't be pronouncing a sentence right now that says you get out today, because then he'd go to Clayton and then be released in Clayton. And I suspect we wouldn't see Mr. Burwell at Hope House, or Hope Hall. Thank you for that information. Mr. Burwell, tell me, are you taking any medication right now at the jail to help with your mental health concerns?
No.
Have you ever taken medication to help with that?
Yes, when I was younger.
Okay.
I was adolescent.
Okay. And for what diagnosis were you taking medication?
Bipolar, PTSD. I've been in the like foster a DFAD system, so I was taking like mental health medication. Then when I got within age to refuse it, I stopped taking it.
Okay. Why'd you refuse it?
Because it was slowing me down, like weight wise. I was zoning out, stuff like that. So when I started taking, I realized I could catch up with my peers.
Okay. You understand that if you go into drug court, it may be that one of the requirements will be that you have a mental health evaluation, and that if a doctor there prescribes medication, you'll need to take that in order to stay in the program.
Yes.
Okay. And you're open to that because no one's going to force you to take medicine. You'd be able to say, because you're of age, I ain't taking that stuff. But if you won't take, in particular, bipolar medication, then drug court, just like you have the right to say, I'm not going to take it, drug court has the right to say, then you're not in drug court. But that's a condition of your probation. So you're sort of in a box if you think you're not going to be willing to take medication. What's your thought about that?
I understand.
Okay. So you'd be willing to take the medication?
Yes.
Okay. And obviously, if the initial prescription has side effects that don't work for you, then they need to give you a different prescription. But it's not really going to be optional if you want to stay in drug court, you taking the mental health medication. Okay. You really worked at a place called Stoner's Pizza?
Yeah, on Georgia State campus.
Okay. Ms. Durden at the time was sort of someone you were talking with?
Yeah, that's passed.
Okay. Staying away from her won't be an issue? Okay. You say that's passed. It wasn't all that long ago, but.
Nah, we only been talking for we only had been together for 7 months.
Okay.
It wasn't that long.
Okay. All right. Do you have any questions about anything we've discussed?
No, Your Honor.
Okay. You understand that I'm about to accept your plea, and the sentence I impose is going to be pretty close to what your lawyer just asked for, but all that's on hold while you go down to Clayton County. You'll need to go down there to deal with the probation issue that you've got. You understand that?
Yeah.
Then we'll get you back here. I mean, if Clayton County, how much time does he have in Clayton County, Ms. Simpson?
His case in Clayton expires September 7th of 2030.
Okay. So you got a few more years, 5-ish years in Clayton County. My hope is they see this sentence that we're trying to get you help in the form of drug court, and they say, great, that'll be a condition of your Clayton case as well, that you participate in drug court. But they get to make their own decisions down there. And so if they revoke you for a few years, all this gets put on hold. Just want to make sure you understand that.
All right.
Okay. All right. Well, if you don't have any other questions, I find there's a factual basis for your plea, in that your plea is knowing and voluntary. All that means is the voluntary part means no one's forced you to enter this plea. And the knowing part means that you've understood what people have been saying. And when you didn't, I watched you do it, you asked your lawyer questions. Do you feel like that's a fair statement, that you've understood what we've talked about and no one's forcing you to enter the plea?
Yes, Your Honor.
Okay. I'm sentencing you pursuant to the Probation Options Management Act. And all that means for you is that while you're on probation, if you have a minor violation, you and probation can resolve that. But if it's more significant, you get arrested or you get terminated from drug court, that'll come back in front of a judge. Okay? There are 2 drug court judges. I'm one of them. And so you may end up in drug court with me. That's just a coincidence. It's not that, oh, I took a plea in front of McBurney, so I'm in McBurney's drug court. It's 50-50 chance whether you're in front of me or a different judge. I look forward to working with you if we do end up working together in drug court. But I didn't want you to be surprised if you were suddenly back in here again. All right?
Yes, Your Honor.
So on count 1, I'm going to sentence you to 6 years to serve. Well, this Clayton situation makes it more complicated. So what I plan to do, but I may hold off on signing the sentence until we get you back from Clayton. But know that it will be structured like this. Count 1 would be 6 years to serve 8 months with a balance on probation. Same sentence for count 2. Count 3 would be 8 months to serve. Count 4 would be that 6 years to serve 8 months, balance probated. Count 6 would be 8 months to serve. So all that stuff combines to 6 years to serve 8 months, balance probated. You've already done 8 months. And then count 5 has to run consecutive and has to be 5 years, but I'll suspend that. So basically your sentence will be, once you sort out what's happening in Clayton County, will be 5 years and 4 months of probation. The main condition of your probation will be, it's a special condition, that you enter into and complete drug court. So you're committing to it. You're going to get through it. Another special condition is that you complete a family violence intervention program, if that can work with drug court. If that's too many classes at once, then we cancel the family violence intervention program. Was there a no contact with Ms. Durden? I hope there was. I'm gonna add that.
Yes, there is.
Okay. It sounds like you and Ms. Durden are done, but it needs to stay that way. So don't look her up when you get out. And if she happens to move in this circle, you need to move in a different circle. If she's able to take a picture of you, that means you were in her space, and that'll be a problem while you're on probation. Okay?
Yes, sir.
I think that's it. Anything else from the state, Ms. Dilligard?
Nothing further from the state judge.
Ms. Rios, on behalf of Mr. Burwell?
No, Your Honor.
What do we do about reporting instructions? It's sort of up in the air because there's Clayton and Mr. Burwell will be in drug court. So that's an Officer Evans or whoever's assigned there. Does he nonetheless have an independent obligation to first sign up? Because his first stop will be Hope Hall. They're going to pick him up, and that's where he'll start.
Within 48 hours of his release.
He should make sure that he reports to the. Okay. All right. I'll let you tell him that on the record. And Mr. Burwell, I was asking the folks from probation is, when do you do that initial reporting to probation here in Fulton County? If Clayton County decides to run their case in through drug court as well, you don't have to report to Clayton and Fulton. In fact, while you're in drug court, you generally don't need to report to probation because probation is part of drug court. And you, as long as you are reporting to drug court, that checks the box for probation. Okay. Will you need housing when you get out?
Most likely.
Okay. All right. Listen to Ms. Simpson from probation about your reporting obligations. And I think we're done for today, and I'll make sure we get you headed towards Clayton.
So when I come back, I have to see you again?
No, sir. Once we know you're back, then drug court will let me know I can sign your sentence. And then they'll get you the next Tuesday. So if you come back on a Thursday, orientation is every Tuesday at Hope Hall. And they'll get you, they're able to check people out of the jail. Hope Hall is about a block from them. You can see it if you've got the right window at the jail where Hope Hall is. You get your orientation, and then they'll help you get to the housing that we line up for you. And then you get a MART card and get you back and forth to Hope Hall. Okay?
Yes.
All right.
And Clayton, they'll do a release or something to let Clayton know that he can get him.
Yeah, we'll manage that.
Mr. Burwell, do you have an address you want your release?
He'll be homeless. That's what you can do.
Okay, so you're going through your 4 reporting instructions once you have the release is to report to 276 Memorial Drive. That is going to be in Atlanta, Georgia, 30333. And it's an outside and it's under here. And it's just what we've been
Okay. Any questions?
No.
All right. Here's hoping Clayton says, let's get this guy into drug court. That'll get you here sooner.
All right.
Mr. Body. Two things. One, I am sorry to hear about your dogs. Judge Carnesale filled me in. That's rough. I try to keep my dogs staggered by a few years so you don't get the double whammy. And it's gonna break your wallet. Yeah. But I'm sorry to hear about that. That is never easy. My lab is at that phase now, but it's one where it's just like, it'll just need to end quietly. It's not a fixable thing.
Mine is probably there. I'm just real content on it.
Yeah, well, more power to you and UGA. Number two, we needed an update on, and Ms. Beza relayed it, but she said, I think those cases will work out, although she only gave 3 names.
I've been talking to
Ms. Cabrera?
Yes, and she's kind of the ringleader. The other lawyers are difficult to get in touch with.
Although Regis was here.
Really?
Yes, I was like, wait, are you Mr. Regis? And he's available both weeks for trial.
Of course he is. So she's going to speak with her client. Resolution is very likely.
Okay, she's on a leave right now, but I'm glad she's talking to you despite the leave. Okay.
Right before we were supposed to go into just hard sell.
Yeah.
3 hours. Sure.
Yeah, the juror will be there tomorrow.
That's what I hear.
Or the juror will be there tomorrow.
So she's gonna continue to, we're gonna keep going back and forth. I believe she comes back next Tuesday or Wednesday.
Yeah.
She's gonna get with her client. It's a joint, collective joint responsibility, taking responsibility for all of this would be great.
Yeah, so you haven't been talking with Miss Feely?
I have not spoken to her. I've been speaking with Euphemia and she's been kind of communicating
With the others? Okay, and then there's Ms. Bumpus.
No one's communicated with her.
No.
YouTube and Twitter have, but not us.
Okay. All right, thank you for that update.
Thank you.
Oh, I have one quick question for you. Let me make sure, before, don't leave quite yet. Are you Mr. Tiller?
Yes, sir.
Great, we're gonna take your plea in just a second. I need to see you right over there.
Look, it is not my fault. We have one more plea and then some bond hearing. Look, I am the one who should be playing. I have a 2-year-old.
Yeah. He planned it.
Hey, planned it. Yeah, I'm saying that to you, son.
Well, like,
When we said we could have done it
too.
What time did you want to work yesterday?
I was working here a little bit later, like I don't.
Oh,
Here again.
they wore her out.
Really turned up yesterday, so I was like, I'll have to.
I have a question.
Yeah.
So, what's the guy said, the guy?
You guys doing
A plea on Tiller? He's not gonna sign the order until once he gets back. Does that mean that he's not?
We good.
I'm like, he's only going for 6 guys. I don't know. It
says 7 right here.
Hey, 7 on the screen.
No, it's so if they were trying to do something right now. So Tiller's a plea. It's a hold to his back.
Tiller's a plea and then
And that's like.
she was saying something.
I mean, that's pretty much what I was trying to figure out when I was asking that question. He said he's gonna work it out, so.
Maybe I need to ask that.
Yeah, maybe ask him. I don't know.
Yes, ma'am.
Can I ask a question? Farwell, right?
Yeah.
Because I was sending an email to the officer in Clayton County letting him know the outcome. But, right now, the sentence that you just gave is on hold until he goes and handles Clayton County.
Well, only because the way I structured it, he'd be releasable today, and so he'd be released to the hold. But then let's pretend Clayton County said we revoke a month. He would get released to the streets, and I want him to be in Rice Street when he is released to drug court. So I'm not going to change my, if Clayton County says we're revoking 3 years, that's unfortunate, but my sentence will be my sentence. It just means he's not going to get drug court anytime soon.
Okay.
I'm hopeful that the judge down there would say, oh, someone's getting him help, so let's revoke him into Fulton's drug court.
Okay. I just needed to know how to, let the officer know what's going on.
Yeah.
He will be, getting sentenced and everything.
Yeah. It's not like, oh, I'm not sure if he's guilty or anything.
Conviction or anything right now, because I'm hold to become.
Right. And if somehow you learn from Clayton, like, no, we want to have the conviction in, we'll come up with the sentence. I can always modify the sentence to change it so he can. Okay, great. Mr. Tiller, you've been very patient. Appreciate that. Let's get on the record in your case. It's 24 SC 004117. You are here in court with Ms. Rios, and Ms. Nix is handling this for the state. In a moment, Ms. Nix is going to swear you in and then ask you a bunch of questions about your rights in your case, et cetera. You'll answer those truthfully, and hopefully you will also let me know if you've got any questions about what's going on. If something's going different from what Ms. Rios had told you, you say, wait a minute, I thought something else would happen. Will you do that?
Yes, sir.
Okay, we're going to do one thing out of order because we have someone on this call who needs to go, but is going to be able to give me criminal history information about you. Normally I get that at the end, but Ms. Jackson, I'm going to ask you to share with me Mr. Tiller's criminal history information, and then you are done after a long day.
Thank you, Your Honor.
As in, I'm ready to get it from you now.
Sorry. He has 21 cycles. The last arrest was September the 24th, 2024, out of Gwinnett County for a probation violation. He was arrested in Gwinnett in 2014 for some charges that were associated with the CWAC. I apologize for the phone, Your Honor. And the conviction was not listed in the GCIC. And he does have prior felony convictions. This one in 2010 for carrying a concealed weapon and possession of a firearm by a convicted felon, and possession of marijuana with the intent to distribute. It's an additional conviction in 2010 for possession of Schedule 1 or 2 controlled substance with the intent to distribute. And there was another one in 2010 out of Clayton County for theft by receiving stolen property. And there was one misdemeanor conviction in 2015 out of DeKalb County for giving false information to an officer. Nothing in addition, Your Honor.
Thank you. So at some point, someone can fill in why Mr. Tiller needs to register, because none of these struck me as registry crimes, but we'll get there. Thank you, Ms. Jackson, for your time. You are free to go. I will see you or hear you on Thursday.
Thank you. Have a great one, everyone.
You too. All right. When you're ready, Ms. Nix.
Thank you, Judge. Mr. Tiller, please raise your right hand. You swear or affirm that any testimony or statements that you shall give in the matter currently before this court shall be the truth, whole truth, and nothing but the truth?
Yes, ma'am.
Can you put your hand down? Please state your true, correct, and legal name.
Martez DeVario Eric Tiller.
Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No, ma'am.
Is there a medication that you normally take that you have not taken or been given today?
No, ma'am.
How old are you?
37.
How far have you gone in school?
Kindergarten.
Is English your native or dominant language?
Yes, ma'am.
You understand that you've been charged with the following offense: state sex offender registry violation?
Yes, ma'am.
You understand that you have the right to plead either guilty or not guilty to this charge?
Yes, ma'am.
You understand that if you plead not guilty or remain silent and refuse to enter any plea at all, then the state is required to prove the charge against you at a jury trial?
Yes, ma'am.
Have you had the opportunity to review your rights with your attorney?
Yes, ma'am.
Have you had enough time to speak with your attorney about all of the charges in this indictment against you, including the facts and circumstances relating to each charge?
Yes, ma'am.
Do you need more time to discuss the case with your lawyer, Ms. Rios?
No, ma'am, I'm just ready to get it over with.
So you don't need,
No, ma'am.
are you satisfied with her services?
Yes, ma'am.
Ms. Rios, do you waive a formal reading of the indictment for purposes of the plea?
Yes.
And do you waive any non-defects in the indictment for purposes of the plea?
Yes.
Mr. Taylor, do you remember having been arrested on this charge?
August 1st?
Yes or no? Yes.
Oh, yes, ma'am, I remember.
Okay. Has your attorney advised you of the minimum and maximum sentence for each charge to which you're pleading guilty today?
Yes, ma'am.
You understand that today you're entering a negotiated plea of guilty, which means that the state will recommend the following sentence to the court. State recommends an 18-month sentence probated with the special condition that you comply with the registry requirements.
Yes, ma'am.
You understand that the court is not required to accept the state's recommended sentence.
Yes, ma'am.
You understand that the court has the right to sentence you to the maximum possible sentence on each charge.
Yes, ma'am.
You understand that if the court decides to order a sentence that differs from the negotiated plea you were expecting today, you have the right to withdraw your plea of guilty.
Yes, ma'am.
Are you currently on probation or parole anywhere?
Yes, ma'am.
You understand that your probation or parole may be revoked based on your entering a guilty plea today.
Yes, ma'am.
You understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit.
Yes, ma'am.
You understand that while you're on probation, you must follow all the special conditions of your probation.
Yes, ma'am.
You understand that if you fail to follow all the special conditions of your probation, then you'll be subject to revocation of that probation for the balance of your sentence.
Yes, ma'am.
You understand that you are not allowed to possess or use a firearm while on probation.
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
You understand that by pleading guilty to a felony, you may not receive, possess, or transport a firearm.
Yes, ma'am.
You understand that doing so could result in new criminal charges for which you face a sentence of up to 5 years.
Yes, ma'am.
You understand that by pleading guilty to a felony, you also may not use a firearm in a crime in the future.
Yes, ma'am.
You understand that if you were in the future to use a firearm during the commission of a crime, you would face a 15-year custodial sentence consecutive to the sentence for the underlying crime.
Yes, ma'am.
You understand that by entering a plea of guilty today, you're waiving any and all defenses, including any mental health defenses.
Yes, ma'am.
You understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, to remain silent, to confront witnesses against you, to the assistance of counsel, to the presumption of innocence, and the right to appeal if convicted of these charges at trial.
Yes, ma'am.
Is it your decision to waive these rights and enter a guilty plea today?
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is this a guilty plea entered pursuant to North Carolina versus Alford? Or
Yes.
Alford versus North Carolina?
Yes, ma'am.
Are you pleading guilty because you've decided that it is in your best interest to do so?
Yes, ma'am.
Are you aware that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at a trial?
I understand, ma'am.
How do you plead to the charge of state sex offender registry violation in indictment number 24 SC 004117?
Guilty on the alpha.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you have only a limited right to appeal this guilty plea conviction?
Yes, ma'am.
You understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition.
Yes, ma'am.
You understand that since this is a felony, you have only 4 years from today to do so.
Yes, ma'am.
Judge, had this case gone to trial, the state would expect the evidence to show that on or about February 28th, 2024, the defendant Martez Tiller, after having been convicted of pimping a person under the age of 18 years old on September 1st, 2015 in Gwinnett County. That case number is 14-B-01331-5. The defendant did fail to respond directly to the sheriff's office within 72 hours of his release from prison. The defendant was released from Dooley State Prison on January 9th, 2024, and never reported. The 2015 arrest that was mentioned earlier, I believe she said that she couldn't see what the
Disposition was, right.
disposition of the charge was, and so that is the charge. It was pimping under a person under the age of 18.
Okay.
And that occurred in Fulton County.
Meaning the failure to report.
Yes.
Okay. Ms. Rios, we already heard from Ms. Jackson. I'm curious about the Alford side of things. It's not a deal breaker. but-
Okay, so he initially reported, went to the place where he was supposed to report, and
This is meaning to register, which
Yeah,
would
to
be the
register.
sheriff's office?
Yeah, the sheriff's office. I emailed back, I forgot the officer's name, and she did say he did initially come. It wasn't an appointment time, so they told him to come back. He's saying that they did not tell him to come back and that he did go there. So there's some confusion, but he did initially go.
So in his mind, and maybe in many people's mind, he made a good faith effort. Hey, I'm at the sheriff's office and you're telling me it's not the right time. I'm here. Why can't you stamp my passport or whatever you need to do? Okay. Got it. All right. What else do you want to tell me about Mr. Tiller and this situation?
He was also confused because the charge that he pled to was not, it wasn't on his face involving a child. It was, the facts of it wasn't a minor, but it wasn't on his face. He didn't plead to the pimping charge. So he was also confused of why he needed to report. I did do some research, and it seems like because of the facts of the case, and there was a minor, that based on the law, that he did have to register. When I did some more researches, because on his face too, I was confused because I was like, well, he didn't police anything, but I was doing some research, and that's why he was also confused. Because I know if I'm a lawyer, was initially confused, it makes sense that he was confused too.
So the name of the charge in the Gwinnett indictment is not pimping person under 18 years, because that's sex and a minor, and that would say to me, register.
Did not plead to that charge, is my understanding. It was a
Okay.
reduced charge.
Got it.
Yeah.
Okay, but sometimes the facts and circumstances underlying it are enough to trigger a registration requirement.
That's what I found out, but he didn't understand that when he was taking the plea.
Okay, got it. And Mr. Tiller was in custody from 2015 onward? I mean, he didn't get out till 2024 on those charges, or?
Yes.
Okay,
But my understanding, right? You were in continuous.
2014 to 2024.
okay, 10 years. Got it. All right. I follow all that. What else?
He is 37 years old. He will be living alone when he's released. I've been talking to his mom a lot, so she is a support person for him. He has 4 children, ages 19, 16, 13, and you have a 2-year-old? Two. Nah. All right, and he plans on getting out and getting a job. He already was revoked in this case, in the Gwinnett case for this, so hopefully they don't do another probation revocation.
Okay. Right, it sounds like in September of last year, he was arrested for violating his probation in connection with this. Check something. All right, so you had said 18 months probation, but it's a felony, so it's 1 year, 6 months. It's not a misdemeanor, like 2 misdemeanors. The 18 months probation is felony probation. Okay, all right. Mr. Tiller, you understand that because you have to register, that limits where you can live?
Yes, sir.
Okay, I'm not going to detail with you all the requirements of the sex offender registry, but in particular, it's where you can live and what kind of work you can do. Can't be a school teacher. You can't live near a school for reasons that you probably understand. That doesn't mean you cannot work, and it doesn't mean you can't have your own spot. It just has to be a certain distance away from parks and pools and things like that. But probation will help confirm that when you pick a spot, that's an okay spot. All right?
Yes, sir.
Do you have any questions about anything we discussed?
No, sir, I understand now.
Okay. I'm sorry, there was some confusion before. I find there's a factual basis for your plea, and that your plea is knowing and voluntary. You are being sentenced under the Probation Options Management Act, and that means that while you're on probation for the, how much probation do you have on your Gwinnett case?
I got 3.5 more years left.
Okay, well, this will be less than that, but for the time you're on probation here, if you have a minor violation, you and probation will work through that. But if you get arrested for something new, that'll come back to me. I'll accept this as an offered plea, meaning you're pleading because you think it's in your best interest, but you think you might have a meritorious defense in that you actually went to the sheriff's office. It just didn't end up qualifying as a full registration. I'm going to sentence you, Mr. Tiller, to two months to serve, followed by 1 year and 6 months on probation. So it's a total sentence of 1 year and 8 months. You've done 59 days, so you got one more day, and that'll get you your 2 months, and then you'll be on probation for 1 year and 6 months. And really, your conditions of probation are obey the law, which applies to everyone. But for you, part of the law is make sure you register and comply with the conditions of the registry, like where you live and what you do for work. And I will waive your probation supervision fees for the first 3 months while you get on your feet and figure out a legitimate way to make a living. Ms. Nix, anything else in connection with Mr. Tiller's case?
Yes, sir.
Ms. Rios?
No, Your Honor.
Do you have a sense of where you'll be living at first or not?
Right now, I'm in work release due to me getting revoked for what I got locked up for. So they gave me 6 months work release right now.
And does that mean that includes housing?
Yes, sir.
Where is that?
That's in Gwinnett County.
Okay, all right. I ask only because that's going to affect your reporting instructions. You may already have a probation officer, so it may be simpler, but I'm going to let Ms. Simpson, who's with probation, tell you about your reporting obligations, because you're going to get out before this week is up, and you'll need to make sure you plug in with probation in connection with this case as well.
Yes, sir.
Okay?
What is the zip code for Russians have been released from Fulton and Gwinnett?
30310.
All right, so your reporting instructions are going to be to report on February the 10th. I'm sorry, that's correct.
Your Honor. Can I ask a question?
Sure.
The work release, he said he's gonna be living there?
Yeah, I'm in work release right now.
You in work release right now?
Yeah, man.
For how long?
For 6 months. I get out of work release in June.
A work release, you can't go wherever you want to go?
No, I just gotta go to work and come back.
Okay, so you're right. Good catch. You won't be reporting to probation until you're done with the work release. And that's the Gwinnett situation.
So you can just report to the 276 Memorial Drive. That's here in Atlanta, and the zip code is 30303. And you just report within 48 hours from your release.
Yeah, man.
Okay.
Yeah, man.
Thank you, Ms. Rios. Thanks, Ms. Nix.
Do you need our permission to sign anything?
Oh, right. One last thing. Thank you. It's been a lot of these. Ms. Nix, is it okay if someone in my office signs the indictment on your behalf?
Yes, sir.
Thanks for the prompt. Ms. Rios?
Yes, sir.
And Mr. Tiller, is it okay if we sign your name to your offered plea?
Yes, sir.
We'll do that. Good luck with things.
All right, thank you, sir.
He has the most loyal mom on the planet. He's been here all day. You're locking people in now?
No, it smells better.
Oh.
We can do, which bond hearing you wanna do first, Patterson or?
Wait,
Bond?
what? There's more than one?
Is Patterson, remember Patterson from this morning?
I thought we were doing Rogers.
Oh, let's do Rogers, this is mine.
Okay, let's definitely do Rogers first. Let me find Patterson. Oh, okay. I got childcare obligations in a minute too, so we'll see. My kid's practice is gonna end. Huh? You three? Yeah. All right. We're gonna keep pressing on. This is 24 SC 004406, State versus Derek Rogers. Who's here in court with Ms. Rios. And we're gonna talk about bond. Ms. Rios, this conversation needs to build off of the last one we had. In October, I denied bond to Mr. Rogers. So I'll need to understand what beyond the passage of time has changed. Because I concluded in October of 2024 that Mr. Rogers posed a flight risk and danger to the community and a risk of committing a felony during trial. So something needs to have changed since then. And maybe you're going to convince me that my thinking should change. But generally, we don't have another bond hearing so close in time unless an example would be the state promised you some piece of discovery and they haven't provided it. That's certainly not Mr. Rogers' fault. Or now that you've looked at the discovery, the case looks a whole lot different than what the state said it was all about.
Sure, mainly it's because we don't have an offer from the state, so the state doesn't see, this case doesn't seem like it's going to be resolving anytime soon. In the meantime, he's having health issues, he's disabled, and he never even got a bond that his mom can even try to make.
Right.
And so he wants to at least have a bond that he can work towards, given that he's probably gonna be in custody, it doesn't sound like this case is gonna be resolved in the near future.
Okay. Okay. Then tell me briefly what you think a bond that's appropriate in this set of circumstances would look like.
No more than 10,000. I don't believe he's a flight risk, Your Honor. Does not have any. A 10,000 bond would be very, very even unlikely for him to make. But I know Your Honor probably will go much lower than that. If you were considering it, his mom and he has a disability. He's in a wheelchair. He's not getting on a plane or going anywhere. He doesn't have means to go anywhere. So because of that, I'm asking for a $10,000 bond.
Okay. And where would Mr. Rogers stay?
I believe it was his mother.
Yep. Okay. The person who's been here all day. All right. This was a Uber case or a Lyft? I mean, the allegation is that it was a Lyft or Uber ride?
Yes.
Okay.
And I think either the next day or several hours later, he said that he made him cancel the Uber ride, but that to me, that's the only evidence is the words of the victim. I know that still counts, but he didn't immediately go to the police, and my client is maintaining his innocence.
Okay, and I wasn't getting into guilt or innocence. I just was trying to remember the case. So I looked at the indictment and I was trying to figure out how these charges would fit a set of facts, but I'm remembering now. Ms. Dilligard, tell me your thoughts about bond for Mr. Rogers. And I don't know, you've been tied down in court all day. If you've got any update on the federal angle.
No update on the federal angle. I did let the federal prosecutor know to call her after court today.
Okay. Little did you know that would be 8 p.m.
Yeah, good. So my review of the case, I would be asking for judge to keep him in no bond status. I have similar concerns of flight risk. My review of his GCIC, he has multiple FTAs listed on there. He also has a host of misdemeanor convictions. He has a open to cab case. He also has history in 7 different states from my review of his criminal history, to include South Carolina, Louisiana, North Carolina, Alabama, Florida, Mississippi, Georgia. Also, while reviewing the case, after judge declined his bond last time, which was I believe in October, I located a jail incident that happened November 14th at Rice Street, where this defendant threw a tray at a sheriff's officer in the jail, became very aggressive, said some really demeaning things towards her, threatened her, told her that he hopes that she dies, and was just overall very aggressive towards her. And so I believe that there is a risk of committing additional felonies if he was to be released on bond. I believe that the nature of this incident is very serious. I believe that he imposes a danger to the community. I did speak with the victim, who did write a quick statement for me to read to the record that was in the file. He says, "I felt really scared when he took that firearm. I thought I was going to die. I was not safe for that reason. No one in the community is safe. Please do not release him." I did speak with him today as well. No, sorry. Scratch that. That's better wrong here.
Okay.
That's the statement from the victim. But my concern also is when reviewing the file, the victim stated that during the incident, the defendant and his co-defendants took his house keys and his family's house keys. Oh, sorry. This sorry.
Okay.
So yeah, that's my argument, would be the risk of flight due to the multiple FTAs, also the history in 7 different states, as well as the jail incident that occurred after being incarcerated in Rice Street.
The 7 different states means that in his NCIC, there are cycles from each of those states. It may be you don't have the exact disposition as to what happened in Alabama versus Florida, but there is a criminal history in 7 states, including Georgia, or in addition to Georgia? So we're actually up to 8.
Including.
Okay, got it.
The only felony conviction I see is burglary and hold-in, but there are a lot of misdemeanor convictions.
Okay, understood. All right, Ms. Rios, anything you want to say in response to any of that? You don't have to. I just want to give you the last word as the movant.
Just that, Your Honor, I hope that you would give him a bond. I'm not asking for a UJR bond or, an extremely low bond. It's something that his parents can, or the mom can try to make.
Okay. I don't want to confuse you and your 2 cases. Is this the case where the allegation is that the car went across state lines?
Yes.
Okay, so it wasn't just take me down to the Circle K. It was, we're going to Birmingham or wherever it was.
Perfect.
Oh.
It did end up in Birmingham.
Huh, I wonder how I knew that. Okay. Understood. Okay. What I'm going to do, Mr. Rogers, is that I want to have Ms. Dilligard, I want to give her the opportunity to complete her conversation with the federal prosecutor, because if your case is going to be one that the U.S. Attorney's Office is going to prosecute, when they show up, they take it anyway, and it doesn't make sense for us to take a whole lot of steps in this one if it's going to go federal, as we say. But we also don't wait forever on that. And you've been sitting in jail for a while now, and jail isn't comfortable for anyone. It's particularly challenging for someone working through a physical disability. So what I'm going to do is ask Ms. Dilligard to get back to me and Ms. Rios and Ms. Nelson by the end of the week, so just a couple days, with an update from the U.S. Attorney's Office, knowing that if the answer is they're looking into it, then we're going to go full speed ahead, and I need to figure out about this bond situation. If it's there will be an indictment, or here's a letter saying we're taking this case, then I'm less apt to move our case forward, because we ought not to, it's just going to get taken from us anyway. So I'll know by the end of the week, Mr. Rogers, what we learned from the U.S. Attorney's Office, and that will inform my decision about whether I keep you right where you are in the no bond status, or if I ought to set a bond. And to Ms. Rios's point, it may be one that initially you can't make, but if I conclude that a bond is appropriate and time passes and you can't make it, Ms. Rios will be doing the right thing to say, Judge, we need to talk again, because $25,000 is too much. You can see 2 months have passed and the family doesn't have the money to post that bond. Then I'll need to reconsider, and I'll certainly do that. Okay? All right. Thank you all for being here. In particular, Mom, thank you for being here all day. That's significant to me in knowing that there's actually a support network for Mr. Rogers. All right.
So he was asking because today was final plea.
Right, but you don't have an offer. So let's do this. So that we're making progress with the case, this case will stay on the March 13th trial calendar. Mr. Rogers's final plea rights will be preserved. So if on March 13th, the state offers X and you come in at Y, we can still take that plea. And if the sentence is higher than what you asked for on Mr. Rogers, he can always withdraw the plea like he could today. But there's no point in doing the exercise today, because Ms. Dilligard would say, we don't have an offer, because our sense is that the US government's going to take the case anyway. So I appreciate both sides of it. We're not going to stall the case. It'll keep moving forward. And I'll just think about the bond question more once we know what we hear from the US Attorney's Office. Okay? You guys should go if you want. The last thing is a bond hearing, so.
Well, and you were here, tomorrow is the trafficking case where we were having trouble getting a search warrant.
Tomorrow, I've got a hearing, I'm assuming Ms. Dilligard is doing it. Keon Ponder is, I've got your name on it, actually, so I don't know which one of you is covering it, but his lawyer, Rodney Williams, has filed these kind of creative but funky, it's unconstitutional, felon with a firearm, whatever. So we're gonna have sort of an academic discussion, but that's the only thing that
Dante Edwards was the one that he hadn't got the search warrant, that if the officer comes and doesn't have the search warrant, the case is dismissed.
Oh, I totally remember that conversation. So tomorrow was the deadline for that?
Yes, so.
Okay, it just didn't hit the calendar. That doesn't mean I didn't say it.
I actually was able to get a copy of the search warrant and provided it to Ms. Rios.
Oh.
Yeah, I sent it to you. You didn't do it. You didn't get it off to you then? No.
Well, let's just check emails while we're here, to sort that out. Good. What calendar is it on? Is it on the motions calendar?
Yeah, it's on the same one that Ronnie's.
Okay, I got it. Oh yeah, Dante Edwards, show cause hearing, ADA Megan Nix to subpoena officer. Ooh.
And I did.
Okay.
Well, I had my investigator.
All right. So did you tell Ms. Rios what day you sent it so she can be looking? See the probation people?
I sent it through.
I kind of missed it. It was on evidence.com, so I think I was expecting just like a separate email.
I can probably send it to you, just now, but.
Did she tell it honest when he doesn't have the process?
I don't mind making him show up, but did you tell him he doesn't need to be here?
Not yet, that's why I wanted to talk to you.
Okay,
And
well.
I am not going to, unless you specifically say, tell me, I'm not gonna.
Okay,
But I did wanna just see.
right. Mostly I want to know if Ms. Rios got the email, and we'll work backwards from there. What did we do with Arthur Burke today? He was on the plea and arraignment. Was he
Judge, I believe he was in Cobb County.
Oh, that's the one where maybe in Cobb County, but then she couldn't find, okay. Right, thank you, great memory.
Yeah, we're gonna have to put him on another calendar.
So he's a reset?
Yes.
Okay,
It looks like I do have a search warrant.
Okay, yeah.
all right.
So we don't tell me to show up tomorrow.
I'm fine having him show. It's really up to you whether how much of pain he's been to you. You can blame me that he didn't get called off, but should we have him show?
I mean, yes.
Good, all right, don't call him off. Okay. Cause I'll see that on I will print tomorrow's calendars tomorrow morning when I get here, and there it is. You all don't need to show up for it. Although one of you is gonna be here for Keon Ponder anyway. Okay. No, ma'am, unless you want to. Okay. Are you Mr. Patterson?
Yes, sir.
All right, we're gonna talk about bond in your case, and then we're gonna call it a day so that I don't get fired as a dad. So this is 24 SC 006265. Ms. Rios, you're gonna argue for bond for Mr. Patterson.
Yes, Your Honor. He's 44 years old. He lives in Georgia for the last 17 years. He has 5 children. He was working for a brass company. He's a licensed pipe welder. He does have his high school diploma and did go to a trade school. His current bond is $100,000, which is too high for him to make. I'm asking for a bond of no more than $5,000. He's had some diabetic issues, and he has high blood pressure and high cholesterol, and he's not getting the type of treatment that he or medical care that he needs while he's in the jail. I think this case is a case that we would probably end up going to trial on. There would be for him to fight the case outside. From my understanding, the facts that I know about the case, the victim had only met my client twice. He was a friend of the co-defendant, which was the girlfriend. I believe the victim's ex-girlfriend is the one he's claiming beat them up or beat him up. And my client had nothing to do with it. He knows that he's a friend of the co-defendants, and just included him in the mix, but he had nothing to do with the situation. And I'm hoping that we can, prove that at trial, but for now I'm asking for a $5,000 bond.
So the indictment is a little confusing with the names of the victim, and maybe it's 2 different victims. Count 1 is the aggravated assault, and it alleges that your client and only your client assaulted Tayson Soldrich by pistol whipping Soldrich. Count 2 alleges that all 3 defendants, to include your client, kidnapped Tyson Patterson. So it's a different last name in the first name. But then Tyson Patterson is repeated with the false imprisonment. And so it could well be a mistake. I'm just curious if that was we'll call it a Scrivener's error, or if your client is related in some way to the alleged victim.
That is a mistake in the indictment.
Okay. Okay, I'm not saying that we need to change it right now. The state may want to think about that if it does go to trial, because it's confusing. But to me, it was more important to know, are alleged victim and your client related in some way? And you've described the connection that it's ex-boyfriend of one of the defendants, and your client's admitting or acknowledging, I know some of these co-defendants, I didn't know this guy.
Yes.
Okay. All right. I met the other two defendants. That I'm not following the connection. They're like different generations. What is the connection between Ms. Harrigan, Ms. Francis, and Mr. Patterson?
I believe he's just Miss Francis's friend, and I think the other person is the daughter.
Harrigan is the daughter of Francis?
Yeah, that's what I'm understanding. That's what I thought, right?
Okay. Okay. It's not on Mr. Patterson to know. I just was confused because one of them seemed super young and one seemed kind of young, and Mr. Patterson doesn't seem ancient, but he seems older than. Okay. So what kind of bond is a reasonable bond?
$5,000.
Drop $95,000 on the bond.
That's all he can pay around here. That's the only hope of getting a bond is going through the bill project.
Okay. And where does Mr. Patterson stay if he gets out? I don't need a specific address, but on his own, with family?
His brother, right? His mother, in College Park.
Okay. All right. Ms. Dilligard.
Judge, the state is in an objection to, we're opposed to reducing the bond. We feel though that the $1,000 bond is appropriate, given the facts and circumstances of this case. My understanding of the facts are a little bit different. After reviewing the file and speaking with the victim went over to Ms. Francis's home because she was owed him money. He worked for her at a cleaning service. He had an outstanding check to receive, and also he needed to give some supplies back. When he got there, he was approached by firearms, specifically one from the defendant, brought into the home, beat up really badly, pistol whipped multiple times. He was held in a basement for 2 hours. He was forced to clean up his own blood with bleach and a towel. It was very traumatic for him. I spoke with him. He couldn't be here today, but he is strongly opposed to any bond, and in our circumstances, a reduction of bond. This defendant also has a violent history. He has 4 felony convictions. One, he has a previous aggravated assault with bodily injury quite some time ago. It's out of New Jersey in 2001. But he's also a multi-state offender, having convictions in Georgia, Duval, Florida, and Essex, New Jersey. I also, when reviewing his GCIC, saw an escape charge. That was from 2010, though, in full candor, but that was out of Delaware. So that was also a concern for risk of flight for myself. So based off of his danger to the community and flight risk, I believe that where the bond is set is appropriate.
Okay.
Oh, and one more addition.
Yes.
What I said in the last time that was more appropriate for this case was that during the incident, the victim's house keys and family's house keys were taken from him, and he was threatened that if he went to the police, that his family would die. And so I have also a fear of intimidation.
Okay. And was the Soldrich seems to be the last name of the victim here. Did Mr. Soldrich immediately go to the police so that there are photos of injuries to him? Anything that would be corroboration of this being beaten and detained?
When we're in the file briefly, I do see photos of injuries. I'm not exactly sure exactly when. I know that his sister had to call the police because of his injuries. He couldn't speak.
Okay.
And so, but I do think that was fairly quickly, and I do think that there are photos of his injuries.
Okay, got it. Ms. Rios, anything you want to say in conclusion? All right, Mr. Patterson, it may not seem early in the case to you because you've been rattling around for a while in the system, and I'm mindful of that. But for the case having been indicted and moving towards trial, it's brand new to me. This was your arraignment day. Your lawyers entered a plea of not guilty for you. I need the state to get discovery to your lawyer. So this would be pictures and body cam and whatever the state has that it thinks would allow it to prove up these very serious charges. I'm going to let Ms. Rios get that information, share it with you, and then we can revisit this question of bond. For now, I'm going to leave things as they are, but I think it's important for Ms. Rios to look over the discovery, and then I invite her to refile this motion to say, I've had a chance to digest this some, Judge. I've seen the evidence, and here are 5 reasons why you ought to not view my client as a risk of flight because of connections to other communities, or a risk of committing another offense because of X or Y, or addressing the concern about the victim's keys and family keys being taken. But Ms. Rios is at a disadvantage because she doesn't have that discovery yet. Once she does, I've seen her in action, and she'll be ready to say, here's why you need to think about this again. And I will think about it again if that's what we need to do. Okay. But for now, I'm going to maintain the status quo. Thank you, Ms. Rios. I appreciate it. Thank you, Ms. Dilligard. Thank you, Sheriff's team. Long day. We don't normally do this, but we packed in a lot, and Hiles told me that revocation would be an hour. I know I always need to triple when he says that. Yeah,